ଅଛି ତାଠୁ ଅଧିକ ଅଧିକ ରହି ସାରିଲାଣି।
କଣ କରାଯିବ? ସେ ବହୁତ ଲୋକ ଅଛନ୍ତି କଣ୍ଟ୍ରିରେ, ବହୁତ ଲୋକ ଅଛନ୍ତି। ଦିଅନ୍ତୁ ଦେଖି
ଫୋର ଫେଲ
ଦିଅନ୍ତୁ। ଏ ସମସ୍ତେ ପୁଅର ଆଜ୍ଞା, ଇନୋସେଣ୍ଟ ଲୋକଟା ଅଛି। ୟେସ୍,
ଗୋଟେ BLFL ରହିଛି।
ଦିଅନ୍ତୁ।
May I please your lordship?
23 ମ୍ୟାଟର,
ଆଜ୍ଞା
23 ମ୍ୟାଟର, 2023 ମ୍ୟାଟର
କଣ କଣ ତିରିଶ?
ବେଲ।
ଦିଅନ୍ତୁ।
My lord, one BLFL, my lord. All the co-accused person are released on bail, my
So
lord.
is that creating an urgency?
No, my lord, but
No.
May I please your lordship? May I please your lordship?
Yes.
Lordship, there is a bail application 4448, my lord.
Yes.
Is it possible to list it on
What is the urgency? What is the urgency?
urgency? His wife is pregnant, man.
So have you filed an IA?
No.
All right. All right. You file a memo, I'll see. Okay, what is the number?
4448, my lord.
444 of 2000?
2024.
All right.
Yes.
Yes.
Supplementary list item number 1 for judgment.
Resultantly, the appeals are held to be devoid of merit and are therefore dismissed. There shall be no order as to cost.
Item number 2 for judgment.
Resultantly, the writ petition is allowed. The impugned order under Annexure 3 is hereby quashed. The opposite party authorities, particularly opposite party number 1, is directed to pass necessary order to extend the benefit of career advancement scale of pay in favor of the petitioners by computing the same from the approved dates of their appointments without deducting 5 years from such date. Since the benefits have already been granted by deducting 5 years from the date of receipt of grant in aid, the dues admissible without deducting 5 years from the date of receipt of grant in aid shall be paid to the petitioners as early as possible, preferably within a period of 3 months from the date of production of certified copy of this order. Similar order in the connected matter.
Item number 3 for judgment.
For the foregoing reasons, therefore, this court finds no merit in either of the writ applications. Resultantly, both the writ applications are dismissed, but in the circumstances without any cost.
Item number 4 for judgment.
For the foregoing reasons, therefore, the bail application is allowed. Let the petitioners be released on bail on such terms and conditions as the learned session judge Khorda may deem fit and proper to impose, including the following conditions. They shall appear before the IIC of Sahadev Khunta police station on every alternate day for a period of 6 months, except the dates on which they are required to attend the court at Bhubaneswar. They shall personally appear before the court and session over the matter on each date of posting of the case, and no representation through counsel shall be allowed under any circumstances. Their application is accordingly disposed of.
Item number 5 for judgment.
In the result, the bail applications are allowed. Let the petitioners be released on bail on such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. They shall deposit their passports, if any, in the court below at the time of their release. They shall not leave the territorial jurisdiction of the court below without obtaining leave. They shall make themselves available as and when required by the IO. They shall appear before the court below on each date of posting of the case without seeking representation through counsel. The BL appeals are accordingly disposed of.
Item number 6 for judgment.
In the result, the appeal fails and is therefore dismissed, but in the circumstances without any cost.
Item number 7, trace admission.
My lord, in this case, the petitioner filed the TRPC, transfer of their case 390 of 2009, pending in the file of SDGM Bolange under section 468 and 471. And this petitioner is working.
You want it to be transferred from which court to which court?
Bolange to Kotak, my lord.
Why?
The petitioner aged about 66 years.
Yes.
And he was retired from, he is a senior assistant, retired from district town planning, Bhubaneswar.
Yes.
Director.
Yes.
In the meanwhile, my lord kindly pays 2 and 3 the medical certificate, and he was undergone spinal surgery, and thereafter doctor advised for a knee
Replacement.
Further, my lord, another page 23 is Parkinson बर्तमान कार स्टार्ट हो जाइए जो थे कि 400 किलोमीटर से रनिंग कला वाला कंडीशनर नहीं है bathroom ଯିବା ବି problem
He will appear through virtual mode.
my
I will
lord
permit him to appear through virtual mode. He will appear through virtual mode. Why?
ନାଇଁ ସେଥିରେ ୱାରେଣ୍ଟ ବି ହେଇଛି ଆଜ୍ଞା
ସେଟା
ଯାଇପାରୁନି ସେ
କଥାଟା
ତାପରେ
ୱାରେଣ୍ଟ ପାଇଁ ଯୋଉଠିକି ଯିବା କଥା ଆପଣ ଯାଆନ୍ତୁ
ମାଇ ଲର୍ଡ
ମିଷ୍ଟର ମହାପାତ୍ର ୱାରେଣ୍ଟ ମିଷ୍ଟର ମହାପାତ୍ର ୱାରେଣ୍ଟ ଯୋଉଠି ଅଛି ୱାରେଣ୍ଟ ପାଇଁ ଆପଣ ଯାହା କରିବା କଥା ଯୋଉ ଜାଗାକୁ ଯିବା କଥା ଯାଆନ୍ତୁ କିନ୍ତୁ ଟ୍ରାନ୍ସଫର ପାଇଁ ଟ୍ରାନ୍ସଫର ଆଇ ୱିଲ୍ ନଟ୍ ଆଲାଉ I will permit you to move an application seeking their representation through counsel under section 317, that is allowed. Second is that is permissible. Second is whenever it is necessary during hearing, you being the accused are required to be remain present in the court. So you can remain present through virtual mode. We do it all the time. We do it all the time. For that, the case will be transferred. All the witnesses will come from Balangir to.
cause of action arose at Bhubaneswar, my lord.
So you file a case for that the cause of action doesn't arise in any part of within the territorial jurisdiction of the court at Balangir. That is open to you to challenge that proceeding there under 482.
482 already exhaust କରିସାରିଛି ଆଜ୍ଞା
Court ରେ କିଛି ହେଲାନି।
first hour second hour
ସେଥିରେ ହେଲାନି। ଏପଟେ
ସେଟା
first hour
ଯାଇପାରୁନି
କଣ କରିବା ଏପଟେ transfer ବି ହବନି।
ଏଇ ଯେ unlucky person
Unlucky एकदम पूरा unlucky କଣ କରିବା?
bad written
Bedin କିଛି ଅସୁବିଧା ତ କିଛି ନାହିଁ। He can appear virtually. Can appear କିଛି ଅସୁବିଧା ନାହିଁ। କିଛି there is no problem. ତାପରେ 317 provision is there.
my lord
What are the offences?
468 471
କଣ ଅଛି? କଣ ଅଛି? The petitioner is the accused in Bolangir Town PS case number 151 of 2009, corresponding to GR case number 390 of 2009, pending in the court of learned SDGM, Balangir. Stop. In the present application, he seeks a direction to transfer said case from Balangir to Bhubaneswar. It is
to Cuttack, my lord.
Balangir to Cuttack. No, but you said Bhubaneswar.
Bhubaneswar cause of action Bhubaneswar.
Achha, ठीक है. It is stated that the petitioner is aged about
66
years and is suffering from a host of ailments, including Parkinson's disease. Stop. He is practically bedridden, for which it is not possible on his part to attend to the court on each date of posting of the case. After considering the submissions and the grounds cited for transfer, this court is not inclined to consider the same as valid grounds. Stop. This is for the reason that it is always open to the petitioner to seek representation through his counsel in the court below, as per the provisions under section 317 of CRPC. Stop. That apart, he can also seek permission of the court to remain present virtually during trial. For the foregoing reasons, therefore, I am not inclined to entertain the prayer for transfer. Stop. The transfer application is therefore dismissed. It shall, however, be open to the petitioner to take recourse to the provision under section 317 of CRPC as and when necessary, as also to move the court seeking permission to appear virtually if stop. That apart, the court below shall not insist upon his personal attendance unless absolutely necessary. गोटे डेट रे दरकार हो केवल से अक्यूज स्टेटमेंट में अक्यूज स्टेटमेंट भी वर्चुअली आजकल होउछ
ए जो वारंट है जोटा कि सेटा हम
सेटा हम बुझिपारने
ना सेटा एक्सक्यूज करिवो केने जाई तो परनु केमति करिवो
एटा हम बुझिसालेनी मिस्टर महापात्र
माय
जुआडू हेले गोटे करिया कथा हे पालानी आ कोन करे
अनलकी लोक भाग्य खराब
अनलकी लोक अनलकी कोर्ट
नाही आगे अनलकी वकील आगे
ना ना वकील
नाही नाही आपण को सबले रिलीफ पाइछि मु
item number 8
आज भी तो पाइले
हेला एमती बेले अबे हबो आगे आ सबुडा 100 की 100 कोटी हेलानी
यस आइटम 8
by president order of
but the petitioner, being the wife, she is the opposite party in a MAT case which is pending before the Lord Civil Justice Senior Division, Athagod, my lord. The petitioner wife seeks transfer of the said case, my lord, on the ground that her father, my lord, she is the only, my lord, member in the family. Her father is suffering from cancer, my lord, and she is the only person to look after her
All right.
father.
Take notice.
My lord.
Issue notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow. Tomorrow, by Monday. Release this matter
5th July.
on 5th July. Yes.
My lord, I have filed.
In the meantime, if any application for adjournment is moved by the petitioner in the court below, comma, the same shall be considered, having due regard to the date fixed for hearing of this case.
Oh, yes.
Tribunal 9.
9 is yours.
My lord. May I please, my lord? Here, the petitioner is the wife, my lord. She seeks transfer of the case from the Judge Family Court, Cuttack to Civil Judge Senior Division, Karanjia, my lord. It is a case under section 12(1)(c) of the Hindu Marriage Act, filed by the husband of the petitioner. And
Non-consummation of marriage.
yes, for annulment of the marriage.
Because of non-consummation.
Yes, yes, yes.
All right. Same order.
My lord.
Same order.
Item number 10.
May I please, your lordship? Your lordship, here the petitioner is the unemployed wife and seeks transfer from Judge Family Court Puri to the Court of Judge Family Court Kendrapada. She is presently residing in
On what grounds?
because she is unemployed and has a 2.5-year-old child.
All right. Same order.
Stay order.
Item number 11.
So order of engagement given by the opposite partner 5 Sarapalli
The
Devara
appointment order.
partner A is under challenge. Lordship may kindly see page 10. The during pendence of earlier writ application in which the selection list which is under challenge is pending adjudication.
No. What is the fact? Please tell from beginning.
There was an advertisement in respect of 12 number of posts of Jogan Soyak for 12 Gram Panchayat under one block, that is Sonpur. So as per the person to the advertisement, the petitioner as well as the opposite partner 8 applied for the post supported by their required documents. And it was found during verification that the opposite party number 8, who secured highest mark, only taking into account his extra qualification, that is extra experience, that is salesman. But petitioner was found second highest. But though he was selected as number 1, taking into consideration his salesman as extra experience, but that salesman experience, he was not by that time, he was under suspension. That document is also annexed in earlier writ application and also in this writ application, that he was not by that time a salesman, so he cannot produce the document that he is having the experience and he was continuing as salesman. So it has been counted as an extra mark, and accordingly he secured highest mark only because of that, your lordship. And those selection list is under challenge in earlier writ application. It is a pending adjudication, not taking into that account by the opposite partner 5, who is Sarapant. He gave engagement order to the opposite party number 8. So that's why it is under challenge. You lordship may kindly see annexer, that is 10, engagement order, and he has also stated that they have given undertaking.
What will I see? Which document will I see?
Your lordship, annexer, that is 10.
Annexure 10.
Annexer 10, your lordship, page 25. Mahasa, may I read your lordship?
ये क्या 2022 order?
Your lordship may kindly see 10
Please kindly answer. 2022 order.
sir, mo pagare annexer 10 your lordship may kindly mo page 25 your lordship.
जहाँ डेट है 10/11/2022 तो ऊपर लिखा है
23 sir, 10/11/23.
10/11/2023 हो 2023 हो. So that means तमने on 10/11 माने 7 मास ହେଇଗଲାଣି 7 ମାସ ପରେ ଆପଣ ଆସିଲେ.
Sir, ଏବେ ସେ ଆଣିଲା ଖାଲି ନୋଟିସ ଟା ହଉ ସାର୍, ଦେଖିବା ତା ସାଙ୍ଗରେ ମିଶିକି କନସିଡର ହବ. ଆମେ ସାର୍ କହୁନୁ କିଛି ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର, ସେ ଯୋଉ ଏଲିୟର ରିଟ୍ ଆପ୍ଲିକେସନ ଫାଇଲ ହେଇଛି.
First of all, he is an unsuccessful candidate. So ordinarily, I would not be, inclined to interfere. He says that the other person, he was number two, the other person was selected on the basis of a certificate. At the relevant time, he was actually under suspension. So he could not have utilized that certificate according to him.
Okay.
I don't accept it. So what happened to that suspension, that has to be seen. It may have been revoked. Whatever, how that period was treated. So this will depend on that.
Yes.
You just take instruction. No notice, just take instruction.
No, this has been issued by the Sarpanch.
Yes. It has been issued by, you cannot appear for the Sarpanch.
No.
All right, will issue notice. Then State Council accepts notice for opposite party numbers 1 to 4. 4 extra copies of the writ application be served upon him by Monday, by Tuesday. Issue notice to opposite party numbers 5 to 8. No, district panchayat officer, I think you 6 and 7 also you can appear.
Yes, yes.
Accepts notice for opposite party numbers 1 to 4, 6 and 7. Yeah. Issue notice to opposite party numbers 5 and 8. 4 extra copies, 6 extra copies. Issue notice to the opposite party number 5 and 8 by registered post with AD, returnable within 4 weeks. Requisites be filed within by Tuesday. List this matter
12th July.
on 12 July 2024. IA notice as above. Yes.
Item 12.
Wait, please, your lordship. Yes, I'm challenging, my lords, the order under Annexure 7, my lords, wherein, my lords, the OP number 1, my lords, being the appellate authority, my lords, while allowing the appeal, my lords, the Anganwadi appeal, my lords, filed by the present OP number 4, has directed to disengage me from service and, my lords, to appoint the OP number 4 as an Anganwadi worker, my lords. Now, if your lordship sees, my lords, an advertisement by Annexure 1.
You do one thing, you file second appeal. Second appeal is available.
No, my lords, what I'm saying, my lords, I've taken a specific ground, my lords. It may not be, my lords. There is an alternative remedy. I'm aware, and I am, my lords, I've taken a specific ground also, my lords, that it may not be, my lords, an efficacious or an efficacious alternative remedy.
Why?
Reason being, my lords, I'm showing the rule. Your lordships may kindly see, my lords, there is will be like akin to going from Caesar to Caesar's wife, my lords. Your lordships may kindly see this, my lords, this remedy of going for a further appeal, my lords, has been newly engrafted in, my lords. Now, if your lordship sees that rule, my lords, absolutely, my lords, the time period, or, my lords, the power that is to be exercised, my lords, by the second appellate authority, my lords, nothing has been prescribed, my lords. And from one officer of the state to, my lords, to another officer, my lords, whether, my lords, any interim directions can also be issued by that second appellate authority, my lords. That is also not there, my lords. So, my lords, my respectful submission, my lords, to
Mr. Counsel, we will fall back upon the general principles. The power of the appellate court inheres in it the power to grant interim order. There are several decisions. This is the point of law. I can observe that. I can observe.
Then I'll file an appeal. I brought
File an appeal.
decisions.
I can observe that. I can.
Yes,
I will protect you.
Yes.
Till filing of appeal.
Yes, yes.
Thereafter, he will pass orders.
At least, my lords, let him till the consideration of my IA for interim stay.
Yes.
Till that time, my lords, your lords.
But this submission, I think you are wrong. That is the law. Law is
But
the power to pass an interim order, whatever order, not just an interim order. Any order required for just adjudication of the case. Otherwise, the appeal itself will become non-infructuous. It inheres in the appellate authority.
Now, suppose, my lords, I file an appeal, my lords. The day I lodge the appeal, my lords, and thereafter it takes, let us say, my lords, let us assuming 10 days time to, my lords, to hear my appeal or whatever, my lords. By that time, my lords, if I'm that is why, my lords,
If you are disengaged and supposing you win the appeal, so your position will be restored. There will be restoration of your position.
my lords, still the consideration of
Yeah, yes,
still the
that I
consideration
will-
of
that I
IA.
will. The petitioner is aggrieved by order dated 3/4/2024, passed by the additional district magistrate Jajpur in AWW Miss Appeal number 4 of 2023, whereby his engagement as Anganwadi worker was set aside. And the CDPO and the concerned CDPO was directed to disengage him, her. Her term to disappear, huh? Directed to CDPO director was directed to disengage her forthwith and to engage the appellant, namely Aparajita Satpathy, as Anganwadi worker in her place. Stop. Guideline. This court finds that the remedy of second appeal has been provided in the revised guidelines dated 15/3/2023 issued by the government in the Department of Women and Child Development, wherein as per clause 10 bracket D, any person aggrieved by the decision of the ADM may appeal to the Revenue Divisional Commissioner of the concerned division as second appellate authority within 60 days from the date of issue of appeal second appellate authority.
Sir, it was clause 8 ratio. It has significant over it had disengagement. The clause 8.
Clause 8 G, my lord.
G, yes.
Clause 8 G.
Clause 8 G. This court finds that as per CU, as per clause 8 bracket G of the revised guidelines, the Revenue Divisional Commissioner of the concerned division is the second appellate authority. Further, every appeal is to be made within 60 days. Within 60 days. Stop. This court further finds that the impugned order was passed on 3/4/2024 and the present writ application has been filed on 14/5/2024, which is within time. In view of alternative efficacious remedy available, this court is not inclined to entertain the writ application. Writ application, which is therefore disposed of, granting liberty to the petitioner to prefer appeal before the concerned RDC within 2 weeks from today. Stop. If such, it is submitted that the petitioner has not been disengaged from service pursuant to the order of the first appellate authority till date. Stop. If such is the case, then she shall not be disengaged for a period of 2 weeks from today. Stop. It shall be open to the petitioner to file appropriate application for grant of necessary interim protection during pendency of the appeal, which shall be considered by the second appellate authority after granting opportunity of hearing to all concerned within a period of 2 months thereafter. Yes.
Let's appeal within 2 weeks, protection for 3 weeks, if matters.
3 weeks.
3 weeks. I'm so grateful.
I don't know, 13.
This is the case, my lord, relating to that Dhananjay Charana Dev, my lord, where the authorities have intimated me, my lord, that the cases, this particular petitioner as well as of others, my lord, that is under their active consideration with respect to.
So they should pass some order.
My lord, because of this ensuing election and other things, my lord. Actually, in a bulk leave, my lord, they are actually taking consideration.
They'll have to they'll have to frame, they have to take a policy decision in this regard.
My lord, I think, my lord, without taking consideration, my lord, it is already, they have taken a decision and they are now identifying individual persons taking into consideration the training qualification of those. So they're preparing a chart. And today, my lord, they have also intimated me.
So that will dispose of a lot of cases. They don't have to come to the High Court.
मैं भावुଛି ଏଇ ଯୋଉ ଛୁଟି ପରେ ଆସିଲା ବେଳକୁ
कि नाते टिके पास ओवर कर देगी तब कहते अलर्ट पास ओवर
Item 14.
May please, Lord. Last order dated 26/4/2024. Kindly have a glance. Paragraph 9 of the counter affidavit.
State was directed to take it.
Yes.
In fact, my lord, we have got an instruction, my lord, in this regard. That the stand of the petitioner is that, my lord, he seeks for regularization by creation of the post, and the university, my lord, recommended the matter to the agriculture department. Agriculture department, the administrative department. Now, before taking any kind of decision with respect to creation of the post and other things, my lord, they have to move it for the approval of the finance department. Now, finance department regretted the proposal. The administrative department, that is OUT, my lord, they only communicated the decision. So, my lord, that is what, my lord, on 23rd.
Yeah, but in spite of that, you have also stated in your counter that it being
It is
an
the
autonomous
university
institution, it is open to them.
It is open to university, my lord. That is why, my lord, the administrative department. In terms of that, my lord, that is a latest development, my lord, I think. That it is the university who is to take a decision, my lord, in this respect. But with respect to creation of the post, my lord, because finance department is not a party, my lord. So the administrative department has stated it is a letter addressed to us, my lord. In view of the above, it is requested to make necessary correspondence to the finance department to avail the required instruction or clarification. In this.
No, but let us come to a counter for that paragraph 9. Paragraph 9.
Only after giving a detailed elaboration, my lord, we have stated that.
In paragraph 8, you refer to that regretting. In paragraph 9, you say that the matter relating to creation, abolition of posts and appointment made under OIT establishment is within the purview of the university as it is an autonomous body. This much alone could have been stated so that the ball would have come to their court. They would have either created or not created.
My lord, they may take a decision, my lord, to that respect.
Yes, what do you say? It's a question of creation of post.
Yes, my lord. While my submission is while the interview was conducted and the petitioner was selected, at that time, post was available.
Then it was abolished. It is abolished.
That was abolished in the year 2000. And the interview held on in the year 1995. And thereafter, 2 posts were created because of the retirement of 2 persons. In spite of that, they did not regularize the service of the petitioner. And 2000, it was abolished. In the year 2009, the petitioner was appointed after filing contempt petition before the Son.
No, that's all. That's all. No. Now,
and other.
No. Please. Now, the question is, it again falls back to once a post has been abolished, for whatever reason, it will not automatically be reinstated. That post.
There are 3
There has to be a creation of post.
3 persons were appointed in the year 2009.
Okay.
Out of 3 persons, 2 persons were regularized. They said that in the regularized order, after completion of 6 years of service, their service have been regularized. But except this petitioner, his service was not regularized.
That they have taken a stand because there is non-availability of post. So that post has to be created. Once the post is created, you will also get the benefit. That is what they say.
Other 2 persons were.
Other 2 were no, again, so there was no post.
That
is what I've seen. That is what I'm saying. So this court would like to find out a way in which your client can be accommodated. In view of this, the paragraph 9, and I don't think there is any satisfactory explanation from the state government.
No, your lordship would find from the annex of the 2000, the government issued letter to all the universities, abolishing all the posts. Now they take the stand that it is up to the university to take a decision. The post was abolished.
So you take advantage of it. If the government has written it on affidavit before this court, so you can take advantage of it. You can create a post. to accommodate this person.
Your Lordship, that is the position. Why we made so many correspondence.
But that decision has to be taken by the university. The mandamus cannot be issued. Can a mandamus be issued by the court to create a post?
That's true. Your Lordship.
So that is, otherwise I would have immediately.
That is why the government has directed to abolish chalk board by virtue of the decision of the government.
That was done way back.
2000. Yes.
2000.
Yes.
We are in 2024, Mr. Author.
Yes, ma'am.
24 years have gone by. And when the government itself comes for, it may be a contradictory plea, but it is a plea on affidavit, saying that creation, abolition of posts and appointment made under OET establishment is within the purview of the university as it is an autonomous body. So it is open to you. You should create that post. Rather, you will take instruction in this regard particularly. Now that the government has taken this stand, you have to respond.
Yes, sir.
In this light, it may be disposed of, directing them on the basis of paragraph 9. They consider my case.
All right. Yes. All right. So what will happen is they will have to create a post and then to consider. Yes. But this is an unfortunate case. Is it not?
In one of the letter, my lord, from the government to the register OAT, my lord, that is 11 May 2009, my lord. In para number 3, it has been indicated that thereafter, considering the prayer of the petitioner, the present petitioner, my lord, in case of 481 of 1996, the Honorable Orissa High Court passed order on 16/1/1997 to give appointment to C.L. Patnaik. Why this order was not carried out as done in case of other two persons, though vacancies are available at that point of time? These are the queries, my lord, which we actually, there are correspondences.
So what was the answer?
କିଛି ନାହିଁ ସେ ତାପରେ ସେମାନେ ଲେଖିଛନ୍ତି 19/5/2009 ରେ ଗୋଟେ ଲେଟରଟେ ଲିଖିଛନ୍ତି the Honorable High Court of Orissa had ordered 16/1/1997 arising out of.
No, I will pass a full length judgment.
Yes.
I will pass a full length judgment. You obtain instruction after that. I will call it on the reopening day.
Yes, sir.
I will give you one chance. If in the meantime you can take a decision to create a post and to adjust him, well and good. If not, I will pass a full length judgment. Full length judgment, then how? It will be better. Because this person has been suffering.
It would be better what I suggest for you. Lordship may dispose you directly the university to create a post meter.
Can that direction
take stage to consider the case of the petition.
and that direction be given? And mandamus cannot be issued.
No, that I know, Miller. The Lordship may dispose of you direct to consider the because since already 2 persons.
Lordship pass appropriate judgment after taking instruction from me.
No, not instruction. You see, I will be just, if I will adjourn, I will be just adjourning it to grant them an opportunity to create a post in the meantime. Take a decision rather. Take a decision rather. You cannot force a particular establishment to create a post.
Yes.
No mandamus can be issued. Can a mandamus be issued? I don't.
And because of filing this case and instruction time to time, his salary has been stopped from the month of March. He is not getting salary.
All right. That I will take care. Don't worry. Mr. Patnaik, what do you say? No, because we are referring to certain very interesting correspondence.
Yes, that is already there, my lord, in the record. In our
That will be helpful while passing a full length judgment.
yes,
If such is the case, then a mandamus can be issued.
there were vacancies when his case was not considered. Now, considering that particular letter from the government to abolish the post, now after abolishing, now they want to regularize this particular post by creating another.
Shall we take that into account and ask the university to consider?
Yes.
We can take that into account.
ସେଇଟା ହେଉଛି ମୁଁ ଯୋଉଟା ରେଫର କରୁଥିଲି 11/5/2009 from the agriculture department.
ସେଟା କୋଉଠି ଅଛି?
Respond ହେଉଛି 19/5/2009 annexure B and annexure C, my lord.
Annexure B.
Yeah, that reply correspondence I have given in the instruction manual on the last occasion. That is there.
ଆପଣଙ୍କ company university ଆପଣଙ୍କ company
ଗୋଟେ ଥିବ ଆମେ ଗୋଟେ ଦେଇଛୁ
The instruction dated 23/4/2024.
Post working for abolished.
ସେ
No, it's a full length full length judgment. Many lot of facts are there.
Yes.
Heard further arguments in part. Since the state government has taken a specific stand in its counter affidavit that the decision to create that creation and abolition of posts lies within the exclusive domain of the university as it is an autonomous establishment, comma. Learned counsel, Sri Ratha, learned counsel for the university, wants to take instructions as to what decision was taken by the university authorities in this regard. I'm simply just adjourning it.
My lord, may I submit one thing? Complying your lordship's direction on the last occasion, the information, the sheet as well as the documents which they are relying upon, annexure A to F. Just now, my lord, I was referring. May I be permitted to place it?
Well, it is already there. It is already there on record. Having been filed by Mr. Ratha.
Yes.
Sri Mahapatra and counsel for the petitioner submits that the petitioner has not been receiving his pay from March 2024 without any apparent reason. So, please this matter on if let the petitioner, let the pay of the current pay of the petitioner be released if there is no legal impediment. So, please this matter on 21st June. On the reopening day Friday. On
legal impediment কথা কইলে ফের সে তো তুলসাকে হইরাণ করছে
সে কোন পাই বন্ধ করছেন ମୁଁ জানিনি ମୁଁ কইদি আগে দেই দিন্তু বলি কোন 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 থিবো
এ গরিব
কোন করিয়া don't worry you'll get a judgment. See, all these things have to be taken out of account. In the meantime, if you create a post and do it, Mr. Ratha, using your good offices also, it will be good.
I will also.
Yes, please. That is why I'm giving you one opportunity.
Yes.
So, and this is a person, admittedly, you see, look at annexure B of the document which you have filed, which Mr. Patnaik was referring to.
Yes.
See, the agriculture department writes number of posts of artists was abolished till 24/6/96.
Right.
That is order passed by the Orissa High Court and so and so. Why OUT appointed 2 petitioners, leaving behind another petitioner, Sri L. Patnaik? So this will definitely go against you.
That reply is also there, Miller.
Para number 3.
I'll place
That there was no need and no budget provision to fill up the vacant post. I would stand alone. See, please use your good offices to. If it is done, well and good. If it is not done, then I will pass on. Yes.
Item 15.
obliged.
Your Lordship for the appellants.
Yes.
Lordship for the appellants. Your Lordship, on behalf of my senior SK Das, praying for an adjournment.
Mr. Das had informed me in the morning that they want to take an adjournment in the matter and they want that the date should be fixed for final hearing after vacation. Any date your Lordship pleases. Any date your Lordship pleases.
Learned counsel for both parties request for an adjournment. Let's this matter.
So we come to 22nd July.
The weekly ratio, no? 28th June.
22nd, 29th.
22nd July. All right. 22nd July.
Your Lordship, was one prayer. Lordship, may not record my consensus. He has requested me for that reason.
As requested by learned counsel for the petitioner, place this matter on 22nd July. Stop.
Your Lordship, interim order to continue.
No, the parties are requested to come ready for hearing. Interim order to continue.
29th July, your Lordship. Is it possible on June? Any date on
June? June the week already pack this is a 2019 matter. Otherwise, I would have accommodated. This is a 2019 matter. Other matters.
As
Yes.
your Lordship pleases.
Item 16.
16 pass over.
Item 17.
The petitioner Lordship, a retired employee. He is a retired computer program of the university. And he has questioned the validity of annexure 15 issued by the assistant registrar. And prior to that,
Your prayer is for revised scale.
rationalization scale of pay. But now, while filing the counter, almost all facts have been admitted because I have relied only the decision. Time and again, the university authority felt that it is necessary for rationalization. And accordingly, the chancellor, vice chancellor, registrar, time and again I can say, repeatedly made a correspondence to the government. Government again sought for information. Again, they submitted the matter. And at this juncture, while the matter is pending, even before the chancellor and before the government, now the assistant registrar who was an authority, they rejected the application. This is my entire grievance. And prior to that, what I'm saying, you will kindly just a glance annexure 1. And more particular petitioner retirement.
Annexure 1 is the appointment.
Yes, that is a computer program.
Shubhankar Das.
Yes, why I'm saying that is the post is as programmer. You see what it is? That is very important. So
Yes.
now the distinguished assistant programmer, they are confusing. This is the programmer. And the next page, this is the approval orders. The following employees of the computer center so university are confirmed. That is confirmed. They are the employees of the computer center. And admittedly, two program posts in the computer centers. That is also not disputed. I'm coming. Then I approach the authorities, Annexure 3. That
Authority for what?
for there is some discipline.
To consider my above mentioned case to do away.
Is
Good with the aforesaid discrepancy. Yes, then
the scale of pay is proceeding whether the scale of pay is 10,500 or 10,900. That is the only foreign difference. And I approach the authorities. That is the authorities. Then let's kindly see page 19. Most relevant. The registrar, who is my authority, now he has already recommended my application to the Undersecretary Governor, who is the chancellors. And the second part is relevant. In this connection, this is to bring your kind notice that while one post of programmer in the computer center carries higher scale of pay, that is 7,300 to 10,900, the other three posts carries lower scale of pay, that is 6,500 to 10,500. Even though the scale of pay of these programmers are equal with the scale of pay of the assistant programmer in the computer center, which creates discontentment among the incumbents, and they are presenting hard for upgrading their scale of pay from 6,500 to 10,500 to 7,300 to 10,900, as has been sanctioned for the first post of programmer in the computer center as per the ORSP rules 1999. It is also felt necessary that in order to maintain uniformity in the scale of pay of the post in the same cadre, the scale of pay of the programmer needs to be revised from 6,500 to 10,500 to 7,300 to 10,900. I will therefore request you to move the Honorable Chancellor for kind consideration for revision of the scale of pay of the programmer of the university from such and such and implement the decisions. This is the recommendation way back in 2000s. And they have justified next page, they have justified what is the scale of pay and what is the qualification, all these things.
Yes.
Then the next page, that is page 23, Annexure 5. This is a letter from the Honorable Chancellors.
Calling for certain documents.
Yes, they calling for some documents. Then again the university authority submitted the relevant documents justifying the posts, and the last clarification, page 25 last. The additional expenditure will be made out of the block grant received from the state governments. That is there. But they have made the budget, that is there. The budget provision is also necessary. Then let's kindly skip over the matters. And again kindly see page 28. These are all recommendations in my favor. And the most important is next page 28, Annexure 8. Page 28, Annexure 8. Again, that is reiteration, and again just having 2 lines. Though the post carry the same scale of pay, their designation varies from department to department. The higher scale of pay of the program in the computer center is 7,300 to 10,000. Creates discontentment among other incumbents. The matter may please be placed before the Honorable Chancellor for systematic consideration and kind orders for revision of the scale of pay after said post from 6,500 to 7,300 to 10,900. Then the Honorable Chancellor intimated the registrar to move for the government because under section 22, though it is a formal, but approval of the government is necessary. Under section 22 of the Act specifies provides.
Which act?
That University Act. Orissa University Act, I'll place minutes.
Yes, yes.
That the government approval is necessary.
Which page? Which page?
Act
Page again.
it is page 31, Annexure 9. So they have not referred, but that is necessary. In inviting to a letter number such and such, I am directed to say that the government in Housing Department may be moved. Let's got it. Page 31. May be moved with adequate justification to obtain the concurrence of Finance Department for rationalization of the pay scale of the program and program assistant in the computer center of the university. The proposal of the university along with the views of the government on this floor may be submitted to this office for considerations. Then the government, after getting the clearance from the register, again instructions for information, that is page 32. Rationale programmers.
So we can come to the
Yes.
impure order.
Yes, because now my entire endeavor is the recommendation made by the register, twice, thrice, and also the chancellor, the vice chancellor, and the government sought for clarification. Clarification was again submitted, and at this juncture, the assistant registrar who has no authority rejected my application. That is simple given. Again, I am saying this is letter of the year 2009. That again, the government sought for some clarifications, and that has also been given. The next page I attend on RTA Act. Here also kindly see. Here 33. That is also the admission. With reference to letter cited above, for Shubhankar Das, letter such and such has been considered by the authority, the university, and the office of the chancellor, and the government in the department of higher education have been moved to accord necessary approval. However, the matter has not yet been finalized. They have admitted the matter is pending for the government. Then another correspondence made by the government, that is page 35, annex 12.
This is on a different context, I see. This is on different context. This is not relating specifically to you. Or does it? Do the if at all rationalization of pay scale of program is filled necessary, the vice chancellor with the approval of the chancellor. No, won't. May take approval.
More not specific election.
With the approval of chancellor may take appropriate action as per provisions of law. They refer to that relaxation provision, relaxation clause. Yes.
Page 35 I'm relying again.
Yes.
Again, the government said that my writ application filed by myself. That reference there.
Yeah, all right, but what is the final outcome of this letter? Is that?
No, that is not. Again, in view of the factual background, it is at the national scale of a program or program assistant, national program is felt necessary. The vice chancellor, with the approval of the chancellor, may take appropriate actions.
Yes.
The government again shifted responsibility to the university. Then again, the university sent it to the government. So kindly see.
Yes.
That is the again the matter was in page 36. In view of the above mentioned facts, the matter may be placed before the honorable chancellor for consideration. Again, the register placed the matter before the chancellors. But you got it page 36, last para. Then this is what the chancellor said. Next page 37. Rationalization scale of pay, such and such. In the matter of determination of scale of pay, the university employee prior approval of the government is necessary under section 22(1) of the University Act. They have referred. Therefore, you are requested to resubmit the proposals for rationalization of the scale of pay program, program assistant, and assistant program to the government for considerations.
गवर्नमेंट को जाओ
again से गवर्नमेंट को जाओ देखो गवर्नमेंट अप्रूवल पे जाओ यही स्टेज रे द assistant register now rejected my application and section 22 that your assistant placing I think so for my interpretation it is formal in nature, though it is the chancellor is the final authority and according to the government clearly directed with the consultation of vice chancellor, the chancellor can take a decision.
All posts of officers which shall not include the vice chancellor, teachers and other employees of a university.
Except the post of vice chancellors.
The creator attached to such posts shall be determined by the chancellor, subject to specific allotment of funds for this purpose in the budget.
Budget status. With the approval of the government.
With the approval of the state government.
This much is there. Even if the approval is there, and there, both the chancellor, vice chancellor, government, they have not negatived my case at this juncture. So for this records is there, and they file an affidavit saying that they have not disputed the government as ever negative or the chancellor. Now the vice chancellor, the assistant registrar who has no authority rejected applications.
Yes, Mr. Nath.
I find the counter affidavit. The copy serves to government and also petitioner. It's a question of we also think that we have sent to the representation to government, but still government is pending. You let's see where to go to my counter.
No, what about Annex 15, the impute order?
Yes, sir.
क्वेश्चन करो गवर्नमेंट को तो जाइए गवर्नमेंट को आउट रिमाइंड करो गवर्नमेंट जा करिया कथा करियो को इन टर्म्स ऑफ रूल 22 को ये क्वेश्चन कर दो हैला
ଯାହା କଣ ସେ ଲୋକଟା ରିଟାୟାର କରି ଯାହା କରିବା
आ कोन करा जी परियो
ଏ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ମୋ ମ୍ୟାଟର ଟା କହିଟା
No, no, no.
ଅଛେ ମୁଁ କହୁଛି ନା ଲେଟ୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନେଇ ଯୋଉ ମ୍ୟାଟର ଡିସିସନ ହେଲେ ଭଲ ହୁଅନ୍ତା ଗୋଟେ ପାଉ
all right yes yes
ଗଭର୍ଣ୍ଣମେଣ୍ଟ କଣ କହୁଛନ୍ତି ତାହେଲେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କହିବେ କାହିଁକି ନାହିଁ ନା ହବ
They have not filed any affidavit here.
you don't have to file any affidavit just inform the court whether any action has been taken
Yes.
or is proposed to be taken
In the
All right.
matter.
Heard in part in course of hearing it is brought to the notice of the court that the proposal for rationalization of pay scale of computer programmer with computer assistant computer कौन सा computer assistant has been sent to the has been referred to the government by the university time and again. The chancellor of the university has also directed or instructed the university authorities to move the government. As it appears, no decision has been taken by the government as yet. The learned state council shall inform the court as regards the status of the proposal submitted by the university for approval. List this matter on 28th June.
May I pray one thing? Since it involves financial aspect, I would request my learned friend for the petitioner to implement the finance department as a party.
Yes.
Only higher education is the party now.
You see, higher education is the administrative department.
Yes.
Finance department is the referral department. I don't think it is necessary.
That would be more.
As per the rules of business, any creation of post file will go to the finance department. So that is an internal thing.
Your lord.
Creation is to be made by the administrative department.
Yes.
Shita last lekha hua, this is with this has been concurred in by the finance department. Why the UOR numbers one so etikali ko chhad dabe. How kishan?
Lordship has vast experience.
Little experience, not vast.
both sides experience
Little experience. I was also heading one of the referral departments.
Sir.
Both are the most negative departments of the government, law and finance. Everything that comes, first we say no, then we will consider. Yes. So it will come on 28th June.
Yes, sir.
Item number 18
Item 18. That's all.
item number 19
Matter relating to removal of the GRS mirror. Last occasion, Lordship has directed to file an affidavit.
The collector is also about to act. Yes, any counter filed by Mr. Das? Session Das?
Mr. Shaijananda Das has requested me to make a prayer for some more time to file the.
Prayer for prayer is made for adjournment on behalf of Mr. S.N. Das on the ground that the counter affidavit has not been prepared. Release this matter around 70 matter. July date on 12th July. The counter affidavit be filed in the meantime positively. Interim order to cut. Mobile ଅଛି. What are you doing, Mr. Mahan?
I'm sorry. ତଥ୍ୟରେ ପଳେଇ ଆସିଲି ଯୋଉ ଦୌଡ଼ିକି 17 ଚାଲିଲା ବୋର୍ଡ ଦେଖଉଥିଲେ
Yes.
ମୋର 18
Item 20.
item 18
Wait. It has been passed over.
item number 20
higher education department is required to file counter. With the rejection.
Who has filed counter in this case? Nobody has filed counter.
University.
You have already filed counter. You have filed counter.
Yes.
It is not on record.
And at 4280.
अच्छी देख ली. काउंटर तो नहीं.
Noting is there.
Court noting.
Yes.
Achi.
Third side.
Oh, third item Rochi.
Yes.
That counter will cover all. So you have to file a memo saying that you adopt the counter in all the other cases also.
Yes.
Or that will cover all the cases. The state has to file a counter. Yes, yeah, all right, whatever. No, you are supposed to file a counter within a week. That is what you have said. Mr. Yardas, learned additional government advocate, submits that he has received the instructions and he would file a counter affidavit within a week. What happened?
Because of the interruption of the election, these things have developed.
No, but you have said I have noted it in the order. I passed on judicial order, Mr. Das. How can you not file a counter within a week? You have made a submission. I have noted it.
I beg apology for that. Your lordship may keep it the week after the.
Yardas, learned AGA submits that because of preoccupation of the concerned officer in election duty. He is unable to swear the affidavit for which the counter has not been filed. He seeks for the time. Let's this matter on 28th June. Yes, counter be filed in the meantime positively.
Item 21.
There are 3 cases.
3 cases, yes. The party
For filing that amended petition. Your lordships and filing it now.
report from the mediator indicates that the mediation between the parties was unsuccessful. What is this?
ସେ ପ୍ରେୟାର ଟା ତାଙ୍କର ଭୁଲ ହେଇଥିଲା ବୋଲି ଲର୍ଡସିପ ଡାଇରେକ୍ଟେଡ how to file an affidavit. Specific court ନାଟା ଦିଅନ୍ତୁ.
ପ୍ରେୟାର ଟା ଭୁଲ ହେଇଥିଲା ସ୍ପେସିଫିକ ଇୟର ନାଇଁ?
ଆଜ୍ଞା.
ଏଟାକୁ ଫାଇଲ କରିବାକୁ ଭଲ କି ଦେଖିଛନ୍ତି?
ଆଜ୍ଞା.
ଏଟାକୁ ଦେଖିଛନ୍ତି ତ ଭଲ କରି?
ହଁ.
ଭଲ କି ଏକଦମ ନିଜେ ଦେଖିଛନ୍ତି ତ? ଭେରି ଗୁଡ। ଆପଣ କଣ ଫାଇଲ କରିଛନ୍ତି? ଏଇ ପିଟିସନ ଟା କଣ?
এটা amended petition होला।
ନାଇଁ ଏଇଟା ଏଇ ଯୋଉ ଆପଣ ଅରିଜିନାଲ ପିଟିସନ ଟା କଣ?
TRPC petition।
କିନ୍ତୁ ଆପଣ ଯୋଉ ଏଇଟା ଦେଇଛନ୍ତି ତ ଲେଖା ହେଇଛି an application for amendment of writ petition। ହେଲା? ନିଅନ୍ତୁ। I'll dismiss your application. I granted you an opportunity.
I'll just correct it.
You are a new entrant. You should be doubly careful for these things.
I'm sorry.
Release this matter on Monday. As paid for by land council to the petitioner.
Item 22. Monday ଆସୁ।
କିଛି ଦେଖୁନାହାନ୍ତି। ଓକିଲାତି ଏତେ ସହଜ ହେଇନି ଆଜ୍ଞା।
Monday ଆସୁ।
ଓକିଲାତି ଭାରି କଷ୍ଟ ଆଜ୍ଞା।
May I please, lordship, in this case, after vacation, lordship, as per the.
ନାଇଁ ନାଇଁ ସେଇଟା ଫାଇଲ କରି ରେକର୍ଡ କୁ ନେଇଗଲେ ତାପରେ ଭ୍ୟାକେସନ କୁ ନେଲେ ହବନି।
No, it item 22,
ଓ ଏଇ କେସ୍ ଆଚ୍ଛା ୟେସ୍।
I'm the. In this case, Prashant Kumar Nanda, your lordship.
ହଁ କଣ ହେଇଛି? 2023 matter ଆସିବ କଣ ହେଇଛି?
Both cases are intermediate is there after vacation, your lordship.
ମିଡିଏସନ କଣ ହେଲା? ଫେଲ ହେଇଗଲା।
Yes, my lord, mediation failed, my lord. My lord, the petitioner wife filed this transfer application, my lord, to transfer the case from family court to Bhubaneswar to family court Bhadrak, my lord.
Intermediate is there, both
2
cases.
proceedings are pending in the court of Bhadrak.
Intermediate ତ ଅଛି ଥାଉ।
ତାଙ୍କର ଅଛି, ଆମର ବି ଅଛି।
ତାଙ୍କର ଅଛି। ଦି ଜଣଙ୍କର ଅଛି, ତାଙ୍କର ବି ଅଛି, ଆମର ବି
ସେମାନେ
ଅଛି।
2-3 ଥର ଟାଇମ ନେଲେଣି।
ନେଲେ ନା କଣ? Release this matter. So,
28 June sir.
ତାପରେ
5th July.
on 5th July. Intermediate to continue.
Intermediate.
ତାରଟାରେ ବି ସେ। ନା ତାର ଗୋଟେ କନେକ୍ଟେଡ ଅଛି ତ?
Item 23. May prisoners. Last occasion, the Honorable directed to that to sit together between both the party for the filing of 13B matter. The opposite party also seat this, but there is no communication of the final discussion. Whether
ଟିକେ ସେ କହିଲ ଟିକେ ବାହାରେ ଆଟଲିଷ୍ଟ ଟିକେ ଟିକେ କହିଲ ବଳରାମ କହିଲ ଟିକେ ଆସ୍ତେ କଥାବାର୍ତ୍ତା କରିବେ ବାହାରେ ବସୁଛନ୍ତି। Yes, Mr. Das.
in last occasion, your Honorable directed to sit both the party and decide whether the permanent alimonies and thereafter inform the court matter.
Yes, Mr. Mahapatra, you are up here.
My lord.
Why don't you settle this dispute?
Yes, yes, there is no problem. The problem lies that they have settled their matter
before the Women Commission, and that was reduced in writing. Some dispute arose regarding the amount, and I called upon the party, my friend Mr. Das, along with the party, they sat together. He telephoned me yesterday evening, but I could not contact. So my suggestion is that there is no dispute that marriage is irrevocably broken down. There is no union. Only the remains the amount.
Permanent alimony.
I suggest, if my friend will agree,
I am always agree, madam.
Yeah,
I will call upon the parties. They will say it is their matter, how much. So I suggest one thing. Your lordship may listed.
Why not I refer it to the mediation?
Let her, madam.
Mediation.
Let it.
Or permanent and continuous local adala of the High Court, which is headed by a former judge.
No, my lord. I feel
Yes, sir.
एते दिन आगे पेंडिंग रहिलानी सेठी 130 13 भी पेंडिंग अछि my lord. हमरो मैरिज गोटे जगह हो 13 भी हबो एटा जदी हो के बहुत लेंदर प्रोसेस हबो गोटे सिंपल मेथड से परमानेंट
countered by the DPC cum DEO in one of the cases. And with respect to the other cases, my lord, the respective DEO and DPC, my lord.
Yeah, occasion for yes.
In the meantime, my lord, few cases are also
Well, I'm just because he's not there, that is why I'm passing it over. After I conclude the list, I will again call out.
Yes.
27.
27,
Yes.
28 also.
No, 28 is different.
I don't know 28.
Yes.
Item number 28, your lordship has directed to take it.
Yes, what amount will you pay towards maintenance?
ସେଟା କଥା ହେଇଛି ସେ ବର୍ତ୍ତମାନ 50,000 ଟଙ୍କା ଦେଇଦବ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ କରିଦେଲେ ସିଏ ତାଙ୍କର ମେଡିସିନ ସେଣ୍ଟର ପଡିଲେ ଉଭୟ ପଟ ତାଙ୍କ କଥା ହେଇଛନ୍ତି ତ ସେଟଲ ହେଇଯାନ୍ତା ଉଭୟ ପଟେ ବସିଲେ
50,000 ଟଙ୍କା ଦେଇ ଦିଅନ୍ତୁ।
ଲର୍ଡସିପ ଫିକ୍ସ ଟାଇମ ବିଫୋର ସିଟିଂ ୱିଲ୍ ଆରଟିଜିଏସ୍ ରେ ପଠେଇଥିଲୁ ଏବେ 29 ତାରିଖରେ ପୁଣି ପଠେଇବୁ ହେଲେ ଲର୍ଡସିପ
ବୁଝିପାରିଲେନି ଆଜି ଶୁକ୍ରବାରକୁ କାହିଁ ରଖା ହେଲା ଡେସ୍ପାଇଟ୍ ୟୁର ପ୍ରୋଟେଷ୍ଟ?
ହଁ
50,000 ଟଙ୍କା ଆଜି ଦେବେ ବୋଲି ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ କିନ୍ତୁ
ନାଇଁ ନାଇଁ ସେ ଲର୍ଡସିପ ଗୋଟେ ଫିକ୍ସ କରିଦେଲେ ସେ
ଚାଲାକିଆ କ୍ଲାଏଣ୍ଟ
ସେ ବୋନାଫାଇଡ୍ ସେ ହଜୁର କହିଥିଲେ ଆରଥର ସେ ଦେଇଛି ନା ନାଇଁ ମୁଁ ଆକ୍ଚୁଆଲି ପଚାରିଲି ସେ 9 ଏପ୍ରିଲରେ ଦେଇଛି।
କେତେ ଦେଇଛି? 10,000 ଟଙ୍କା?
15,000 ମିଛ କଥା କହିବି ମୁଁ କହିଥିଲି
not you, it is not you, it is your client. I'm referring to your client. ସେ ଟିକେ ସେ very intelligent. ନାଇଁ ମୁଁ କହୁଛି ଶୁଣନ୍ତୁ, he is very intelligent.
ସେ କରିବ କମ୍ପ୍ରମାଇଜ କରିବା ପାଇଁ ଅଲରେଡି ସେଟଲ ହେଇଯାଇଛି ଜିନିଷଟା ଆଉ
I thought you will be ready with 50,000 rupees draft. Again, ଆଜି ଆପଣ time ମାଗିବେ knowing that the vacation is coming.
ନାଇଁ
ଇଏ କଣ କୋର୍ଟ କଣ ବୁଝିପାରୁନି?
ନାଇଁ I have
Not you, again, Mr. Bhanjada, don't take it to yourself. Don't identify with your client. I am talking about your client, not you. You are an officer of the court. It was your responsibility to convince your client. If your client is not convinced because of his higher superior intelligence.
The client has been convinced. I have convinced.
Hey, 50,000 ଟଙ୍କା କାଇଁ ଆଜି କାଇଁ?
जी से ଆପଣ ଲର୍ଡସିପ ଗୋଟେ 5-6 ଦିନ ଟାଇମ ଦେଲେ ଆମେ ତା ଭିତରେ ଫିକ୍ସ କରୁ ଗୋଟେ ଫିକ୍ସ କରା
ମଣ୍ଡେ କୁ ରଖୁଛି alright serious के भंजो देबला ना
ट्यूसडे को ମଣ୍ଡେ ମାନେ ଇଏ କରୁ ତାଙ୍କ
ଯଦି ନ ପଡିବ ଛୁଟି ଭିତରେ ପଶିଯିବ
ଏଇଟା
କିନ୍ତୁ ଏଇ କୋର୍ଟରେ ପଡିବ ମୁଁ ଆଜ୍ଞା 5ଟା ଯାଇ ବସିଯିବି ସେଦିନ। Mr. Bhanjada, please appreciate the concern of the court. If you pay some amount,
yes,
lady, maintenance.
I have stated
and that will be, you see, that will whatever you have paid, supposing there is some final alimony.
Yes, ma'am.
Will be adjusted.
Yes.
What do you say, Mr. Pradhan?
Yes, ma'am.
2020 ରୁ ଯେ କିଛି ପଇସା ଦେଇନାହାନ୍ତି ଯଦି କିଛି ଆମାଉଣ୍ଟ ଦିଅନ୍ତୁ
Mr. Pradhan, we are not writing on a clean slate.
Correct.
Whatever
ସେ କରିବେନି କହିଲେ ପ୍ରୋବ୍ଲେମ ଇଜ ଦ୍ୟାଟ ସେ ଅଲରେଡି ମ୍ୟାରେଜ କରି ରହୁଛି ବାହାରେ ସେ ତା ଫ୍ୟାମିଲି ସହିତ ସମ୍ପର୍କ ରଖୁନି
ଆମକୁ ଏଡେ ବଡ ଫଟୋ ରଖିଛନ୍ତି
ସବୁ ସେ କଲେକ୍ଟ କରିଛି
ବନ୍ଦ କରିଦିଅ
ତେଣୁ ସେ ଆଜ୍ଞା ମୁଡରେ ନାହାନ୍ତି କାରଣ ଛୋଟ ଛୁଆଟା ଝିଅଟା ମୁଁ ତାକୁ ବଢିଆ ସଜେସନ ଦେଇଥିଲି ଯେ ଯଦି ବାହା ହେଇଛି ଆକୁ ତ ନବାର ନାହିଁ ସେ ଛୁଆ ନାଁରେ
50,000 ଟଙ୍କା ଆପଣ ଦେଇ ଦିଅନ୍ତୁ।
ହଁ
ସୋମବାରକୁ ରଖୁଛି
ମଙ୍ଗଳବାର ସୋମବାର
CSK Bhanjada will and counsel for the petitioner submits on instructions that his client would pay some amount towards maintenance.
Yes.
and he requests for some time for the purpose. Leaves this matter on 22nd June, 22nd May. 21st. 21st May.
21st, yes.
Interim order to interim order to नहीं adjournment
adjournment होतला
या भीतर update अच्छी की
ना
date तो नहीं है उसको
अच्छी की करे सेटा था उसे
हो
interim order complete item 20
interim order तो नहीं
say order
adjournment
if I will through draft or RTGS I will show the
whatever valid proof of payment of some amount,
yes,
which will show your bona fides.
My humble submission, sir. So lordship will fix before the ballot mediation center so that both party will
See that दियो तू देला पर देखिए मेरे को मार कुछ
obliged.
May please lordship. Last time lordship directed to file requisites in speed post. Lordship wrongly filed the registered.
I am allowing it because I allowed yesterday two such matters. Keeping in view the vacation, after vacation, I am going to simply reject it with heavy cost. If you do not comply with the order of this court, it will direct speed post. You will deliver. You will pay register post.
Clerk has been wrongly filed.
So your clerk controls your office. You are saying yes.
No, man. The order has been uploaded.
A judicial order has been passed, and you are saying my clerk did it.
Sorry.
Very strange.
Sorry.
Very strange, Mr. Lenka.
Comply by tomorrow.
So your clerk controls your office.
No, man.
Now let's see. It is submitted that out of because of inadvertence, requisites for issue of notice by registered post were filed instead of speed post. Stop. The requisites filed be accepted, notice be issued, fixing a short returnable date. Release this matter
12 July.
On 12 July. Is there any interim order?
Let's say only representation.
Adjournment. Yeah, adjournment. All right.
Item 30.
May please lordship. Lordship, it's a transfer of CP from Lord Judge Family Court Kendrapada to Kottagiri, lordship.
Family court?
Family court.
What happened to the notice?
My lord.
Somebody has appeared. Mr. Sanjay Kumar Patri, learned advocate, appeared for. He is not there. Learned counsel for the petitioner is present. None appears for the opposite party. Release this matter vacation for good date for
12 July.
12 July, interim order to continue.
My lord. That will.
Item 31.
My lord, on last occasion, my lord directed to mediation center. Kindly peruse the mediation center report, my lord. Out of 5 times mediation date, 3 times is opposite party did not appear. No.
Yes, Mr. Proceed.
My lord,
it is not ready and willing. And
I have to take instruction from my client, my lord.
I'll read it out.
Yes,
the case record is put up to the first party is present, files are there, the mediator waits till the end of court hour. The second party found absent on repeated calls. It seems the second party is not interested for any such mediation. Second party is adamant in his behavior and does not want to accept the first party as his wife in the society. The mediation process fails. The honorable court be intimated accordingly.
Well,
so we allow the transfer application.
Well, that apart, the petitioner, the opposite party, husband, Narayan Rathi, has filed another petition with a prayer to transfer the petition filed by the wife under section 125 of CRPC for maintenance in the court of the Judge Family Court, Keonjhar. That I have filed this application to transfer that petition from the family court, the Judge Family Court, Keonjhar to Kendrapada, my lord. That is pending. In the last occasion, I had prayed, your lordship, that both the matters may kindly be clubbed together and had analogously. And that matter has not come along with this matter, my lord.
Was there any order?
Yes, there is an order, my lord. TRP CRL number 33 of 2024, my lord.
No, there is no such order, Mr. Prusti. Anyway, we will call for and hear it together after vacation, the interim order to continue. The report of the mediator indicates that the mediation proceeding has failed as the opposite party husband did not, was not interested. Stop. List this matter on 24 matter July
19th July.
on 19 July along with TRPC number.
TRP CRL number 30.
TRP CRL number. Why CRL?
CRL criminal proceeding.
No, no, which one?
125 match.
125.
125.
The TRP CRL number
33 of 2024.
33 of 2024.
My lord, I just want to.
Interim order to continue.
Yes, madam. After my petition of the heart, that matter was listed.
That is an independent proceeding. If that is an independent proceeding, can you stop the person from filing an application for transfer? It will be considered on its own merit.
Interim application.
Interim order to continue.
Item 32.
Same.
Item 30.
Same. Instead of speed post, register post.
My mistake.
You have got order for it. All right.
Item number 33.
Same.
Item number 34.
No, 33. Yes.
33.
My lord, in previous order, this is notice was sent through speed post, but we sent in registered post.
Notice when did the notice go? The court directed you to file requisites for a notice by speed post. You will file it by a registered post on your own. All right. Same order vacation for a sub reject.
Interim order.
Interim order to continue.
Item 34.
34 my lord, the CP case number 814.
I have filed a IA under section 340 CRPC for launching prosecution against for filing false affidavit with the lordship.
File an IA?
Yes, no.
Is it 127?
1 page.
Your copy is served?
Just now, sir.
Copy of the IA 127 of 2024 is served on learned counsel for the petitioner who wants to take instructions in this regard and file a reply if need be. List this matter.
19th July.
19 July. Is there any interim order?
Interim order is in their favor.
Interim order to continue.
Item 35.
Pardon, my lord. My mistake, my lord. I will file today, my lord.
Same order.
Item number 36.
Peculiar postal endorsement is there. No such person available. The wife is prosecuting 3 cases. One is Mata, one is a criminal proceeding in the same address. But she has managed the postal piano and the noting came.
The postal notice on opposite parties has returned undelivered with the postal endorsement with an inverted comma. No such person in this address. Sri Satpathy, learned counsel for the petitioner, submits that the opposite parties are willfully avoiding receipt of notice, but they are very much residing in the same address. Stop. Such being the submission, let extra copies of the transfer application be served upon learned state counsel, who shall cause the notice to be served upon the opposite parties through the IIC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on
19th July.
19 July.
Interim order to
continue.
Oh, blessed. Today itself I have to submit the extra.
By Monday? By Monday.
Pardon, my lord, password matter to.
Password ekatra rokavo.
ଏଥିରେ କାଉଣ୍ଟର ଦେଇନାହାନ୍ତି ରହିବ
ମୁଁ ତ ମଝିରେ ଏକ୍ଜାମ ବସି ମୁଁ କରିପାରିବି ନାହିଁ। I will not break my.
Sorry.
Continue.
Item number 37.
Lords, 37, my lords. IA, you lordships may come to para number 3 of the IA, my lords.
Para 3?
Yes, my lords.
Of the IA?
My lords, it's an IA disposed of case, my lords, because there are some typographical errors. In para 3, my lords, the tabular chart is presented for the convenience, my lords.
Very good. So the date is
yes, my lords.
Date
only the dates only, my lords.
All right.
Majorly the dates.
Considering the Submission I record, है ना? Prayer for modification is allowed. The order, the judgment dated essay is modified in the following manner. I ये पूरा एकदम से tabular chart कर दी इसमें. तो रेकॉर्ड कर दो, है ना? You have taken certified copy.
My lord, it's applied, not yet available.
All right, very good.
I don't know, 38.
The present appellant, who has been convicted for 10 years, is inside the custody since 20th 5 2016. Your lordship granted interim bail after release on interim bail. Now he is suffering for that reason. I am praying for 10 years conviction, near about 8 years extension of time for that reason, because he is suffering. For that reason, my lord.
Suffering means?
Well,
Suffering means suffering from what?
that is, I have annexed a chest pain and that is there.
For chest pain,
my lord. Gosti Swasthya Kendra Goniya.
And para 3 on that occasion he has stated that due to chest pain he was
That is
released on
there.
interim bail.
I have
Now
annexed.
he is stating that he is undergoing treatment.
नहीं चेस्ट पेन रे तापर ହେଇଛି ସେଟା 20/5/2016 ର ଅଛି.
prayer for extension of interim bail is made on the ground that the petitioner is has not recovered from his illness as yet. Stop in support of such submission, copy of the copy of the prescription issued by the CHC Gonia in the district of Nayagarh is enclosed. Learned State Council submits that it, looking at the ground cited for extension, the court may pass appropriate order. Considering the submissions as above, the interim bail granted by the order dated so and so is extended by
29/11
by a further period of 1 month.
2 months.
Only vacation. Only vacation, Mr. Das.
Well,
only vacation. Conviction under NDPS Act, 10 years, I have already granted enough relief.
8 years, and your lordship knows that the judgment of the apex court is on court granting after 50% of conviction, if he has suffered, then granting.
No, that is not a rule of law. That is not in every case.
Otherwise, I have got a good case.
That I have noted, taken note of. Yes.
Item 39.
My lord, please.
My lord, first, I am for a petition number 2, my lord.
Petition number 2.
Yes, my lord, IA 1684/23 not press, my lord.
1684.
1684/23 not press.
IA 1684 of 2023 not pressed. Yes.
And my lord, 1016/24 for bail, my lord. 20B to C NDPS 75 kg and 12 year the sentence, my lord. The accused in custody 9 years above.
Yes, what do you say?
My lord, kindly see order dated 16/1/24.
16/1.
16/1/24.
My lord, one thing, my lord. He is 3 times in interim bail and surrender. Surrender certificate I have filed. Only Sarath Kumar Sahu, petition number 2.
Granted interim bail.
Interim bail, my lord. 3 times.
I have granted already interim bail.
Interim bail 3 times, my lord. I want to bail, my lord.
Irregular bail?
Yes, ma'am.
No. No.
My 12-year sentence, my lord. 12 years, I have already 12 years above.
No. This is NDPS Act.
NDPS 75, ये 5 kg, my lord. सब गुड़ा हम रोके 75 kg, my lord. 2%, my lord. 2%, 2 bikes.
So
half and half, my lord. Yeah, another.
माने ताकरो जो punishment होगा सेटा भी half half हीजो.
No, my lord. No, my lord. No,
No, you just said
absolutely not,
half,
my lord.
no, you just said half half.
No, my lord. My lord, 2 accused.
No, I did not know. Probably the law may have changed. I did not know that. I'm not supposed to know the law.
Sorry, my lord.
No, why sorry? Why sorry?
ମୁଁ ଯୋଉଟା ଠିକ ସେଟା ମୁଁ କହିଲି 2 accused ଥିଲେ.
ସେବେ ଦି ଜଣ ଅଧା ହେଇଯିବ ସବୁ. ସେଇଟା ତ ଠିକ ଆପଣ କହିଲେ ଆଉ. ମୁଁ ବୁଝିଲି ଆଉ. Anyway, surrender certificate file କରନ୍ତୁ please.
ମୁଁ ଫାଇଲ କରିସାରିଲି.
କହିସାରିଛନ୍ତି?
Yes. ମୁଁ ये
surrender certificate ଦେଖି.
My lord, I have Xerox copy. I have already.
ଦିଅନ୍ତୁ. ସେ Xerox copy ଟା ଦିଅନ୍ତୁ.
This is the Xerox. କେବେଠୁ ଫାଇଲ କରିସାରିଲି?
Yes, he surrendered on 20th April.
20 April.
1 month, I'll grant. As per the copy of the surrender certificate indicates that the petitioner, that the appellant number 2, surrendered to custody on 24/2024, after expiry of the period of interim bail.
No, said it. Sorry. Sorry, my lord, sorry.
It seems I'll end up being sorry. The prayer for interim bail, prayer for further interim bail has been made. What is the ground? Ground which the court has to invent. The ground.
My interim bail, the bail, my lord, see 9 years above 12 years sentence, my lord, 9 years above say royal and 3 times he is released and interim bail and you must surrender each and every day only for petition number 2, my lord.
All right.
Every time.
All right. No, the regular bail I'll not grant. Prayer for bail is made on the ground that the petitioner, that the appellant number 2 has already spent 9 years in custody from out of the substantive sentence of 12 years imprisonment. They submitted that the appeal is not yet ready for final hearing. So, this court observes that the appeal is of the year 2018. Taking note of the delay in disposal of the appeal, the appellant number 2 has already been granted interim bail on 3 occasions. He has surrendered to custody in time without misusing his liberty. Learned State Counsel has opposed the prayer for bail by submitting that there is clear evidence against the petitioner, against the appellant, for which he was convicted rightly by the court below. And there is every possibility that the impugned judgment and sentence shall be confirmed by this court. Considering the rival submissions and the materials on record, this court is not inclined to grant regular bail to the appellant. However, considering the delay in disposal of the appeal, this court is inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 1 month. Yes.
Item 40. May I please? This I have filed for modification of the order, my lord. In the order that is at page 11, relevant portion is at page 12, my lord. Last para, my lord. Accordingly, the Judge Family Court Baleswar is directed to transfer the record of civil proceeding number 552 of 2017.
Oh, this is Justice Prasad's order?
Yes, madam. 552/2017 to the Court of Judge Family Court Bhubaneswar. I only seek modification that Family Court jagare Family Court 2. Sati. Because the order to proceeding. No.
Modification ଆପଣଙ୍କର କଣ କହିବାର ଅଛି? Unless it is your case that it is not really, it should not be transferred to that court. Anyway, considering the submissions, the prayer for modification is allowed.
1 to 1
in order dated 27/2018. The figure 2 be added after the word family court, bracket within bracket, family court, and before the word Bhubaneswar.
Item 41. His presence may be noted.
Nothing. Modification or presence con?
I say appeal করছেন তো?
I see করুন।
তলা করবে যে কোন আমি appeal করব।
I see করুন।
41 pastoral lordship. In fact, Mr. Dhali is held up in.
Hold on.
Item 42.
Please, lordship. This is an application.
41 times.
I'm sorry.
Here in item number 41.
This is modification you want?
Extension of interim bail. Madam, bail period is expiring at 1st June. If it can be extended for 2 months more.
What?
1 My Lord friend says, oh, seriously.
He is the Advocate General. He will direct his officers.
Cost first କିଛି ବାହାର କରି ଦିଅନ୍ତୁ 3 ମାସ extension ହବ କିଛି ନାହିଁ।
ଦେଇଛି ନା।
Yes,
Madam, 29/1/24, your lordship granting interim bail. He is direct involved, eyewitness is there. That's why. So,
I'll grant till the end of vacation.
First week of July.
आज ये केते 17
24th well.
17 जाए हो आरो 17 जाए
24th
आज्ञा 17 जाए हेले ठीक दिस इज अ वेरी डेंजरस क्रिमिनल
नहीं किछि आउ antecedent आउ तापर किछि नाही ना after
impose many stringent conditions of course he shall appear before the IIC of Chandipur police station on every Sunday at 10 a.m. and all that all those things all right CDP Dhara learned senior counsel submits that the petitioner requires some further time to prepare for his defense and to instruct his counsel accordingly. Stop. He therefore prays that the interim bail granted by this court by order dated 29/1/2024 be extended by a further period. Stop. Then State Council opposes the prayer for extension of interim bail on the ground that 3 months 3 months time has already been granted to the petitioner and therefore no further liberty should be granted considering his role in the alleged occurrence. Taking into consideration all the rival submissions and the materials on record and the ground on which the prayer for extension of interim bail is made, I am inclined to allow the same. It is directed that the interim bail granted by order dated 29/1/2024 is extended by a period of 1 month. On the same terms and conditions as mentioned in the
1 month of the date of expiry, well, 1st June it is expiry.
1st June. All right, 1 month from the date of expiry. Yes.
Item 42. May it please your lordship. My lord, may kindly turn to para 15 of the order. I am seeking modification of that.
Yes.
May I place this? For the foregoing reasons, therefore, CRLMC is allowed. Court directs that the case be handed over to reinvestigation by CID crime branch. Having regard to the fact that one of the accused is himself a senior police officer in the rank of DSP, it would be proper if the investigation is conducted by an officer of the higher grade. Kindly note that higher grade. This court therefore directs the additional director crime branch to entrust the investigation into a senior officer not below the rank of DIG, who shall reinvestigate the matter. We don't have DIGs, so now IG is doing it. Now the IG is a little overburdened. So what I was submitting for your lordship's kind consideration, let the superintendent do it and let the IG supervise. This is all I'm asking.
Superintendent.
SP. Because he is DSP, there is no DIG. The IG is otherwise in charge of several departments. He will supervise and let the SP be the IO.
Under this, you mean to say under the supervision of the IG?
IG.
Fair enough. What is
My lord, I am permitted to assist, my lord. There is little legal impediment, my lord. Though they have not complied the order, the petitioner had filed a contempt. That was the order, my lord. I want to read.
6 months time was granted.
My lord, page 3, paragraph 3, I am reading, my lord.
So this will.
Yes, my lord. What, my lord? In that contempt, the order has been modified. I want to bring your lordship's notice, page 4, my lord. Since the order allegedly non-compliant has not stipulated the time frame for completion of investigation, except directing the previous IO to hand over all the files case diary to the CID crime branch, no contempt as such is made out against the contender for not completing the investigation.
No. The submission made by Learned Advocate General has been noted.
Yes, ma'am.
On that assurance, the contempt was dropped. So the order remains as it is. Order has to be modified.
360 is bar, if my lord pleases.
What 360 is a bar?
My lord, because.
No. 360 is a bar.
362.
362 rather, to review and recall the order.
As my lord pleases, my lord, I don't have.
No. You have raised the topic. Please. Let it go to its logical conclusion.
Only
It's
my lord.
not a
But
joke.
because my lord,
It is not a joke, Mr.
no, my
Bharti.
lord, it is not my lord.
The law doesn't operate in a vacuum. If there is no officer to whom
Yes,
the
my lord,
court has
I'm not there, my
directed,
lord. Because the IG,
ଆଜ୍ଞା ଟିକେ ଆପଣ ଶୁଣୁନାହାନ୍ତି ଆପଣ ଟିକେ ଆଜ୍ଞା ଶୁଣୁନାହାନ୍ତି advocacy is listening to what the court says.
my lord.
So if the law can the law operate in a vacuum? Supposing I have directed that the DIG shall conduct the investigation, there is no DIG. So that means the order of the court will never be complied with. What he seeks is basically compliance of the order. Polite. Third, learned advocate general for the state. Stop. It is submitted that there being no officer in the rank of Deputy Inspector General of Police, the order passed by the judgment of this court and the direction contained in paragraph 15 is unable to be complied with. Sir, correct me if I'm wrong.
No. Actually, IG is doing it now.
I will record it.
Yes. Yes.
He further submits that the Inspector General of Police is in fact investigating into the matter. But being a senior ranked officer, he is preoccupied. No, his preoccupation with other administrative matters.
Your Lordship, may
is
kindly
preventing
see,
him.
my lord, paragraph 5 of my application. I have said what all he is dealing with. Since my learned friend is raising an objection.
I'll simply say,
Yes.
as referred to in paragraph 5.
I'm grateful.
Prevent administrative matters, more particularly referred to in paragraph 5 of the
My lord.
petition, is preventing him from devoting full time for investigation of the case. Stop. He therefore submits that the superintendent of police may be directed to investigate under the expert supervision of the
I'm grateful. IG police.
IG of police. Stop. Sri Mahanti.
Superintendent CBCI.
That I will write. By the direction I will write. I will correct it. Mr. Mahanti, should I write your objection or has no serious objection?
No help.
On the first date, I was about to dismiss your application. And you will remember how much you have argued and what I have written in the judgment. That you will remember.
Yes.
It's not for me to say. Sri Mahanti, learned counsel for the petitioner, has no serious objection to the prayer for modification being granted. So, having heard learned counsel for the parties, having heard learned advocate general and learned counsel for the petitioner, and having also perused the prayer for application for modification, particularly the amendments made in paragraph 5 thereof, I am inclined to allow the prayer for modification. The IA is allowed. The impugned, the judgment dated 5/7/2023 is modified only to the extent of substituting the word. Sir, it will be
DIG. It is
substituting the word Deputy Inspector General of Police by Superintendent of Police Crime Branch. CIDCB. CIDCB.
And supervised by
under the experts. CIDCB. Who shall investigate, submit a report to concerned court. Who shall reinvestigate the matter from all angles. Further, the word under the supervision of Inspector General of Police be added after the word angles and before the word and occurring in this paragraph.
Grateful.
I'll again. Actually, is the IG? Has the investigation revealed anything further?
Right, check.
But the investigation is going.
Yes.
Item 43, my lord, so interim bill, extension of interim bill, my lord, due to ଆଗରୁ ଥରେ ଯାଇଥିଲୁ ମଧ୍ୟ ବେଲ୍ କରୁଛୁ ଠିକ ଟାଇମରେ ସରେଣ୍ଡର କରୁଛୁ ଆଗରୁ ଥରେ ଯାଇଥିଲୁ ସେ ମାଙ୍କ ଦେହ ଭଲ ପାଇଁ।
Bill granted for 1 month on 13/3 and on 16/4 it has been extended for 1 month. And case of 30
ହେଲା ଭ୍ୟାକେସନ ଟାକୁ ଡେଇଁଦବ ଭ୍ୟାକେସନ ଟାକୁ ଡେଇଁଦବ
last chance, Lordship may say.
considering the submissions the interim bail is extended by a further period of 1 month. It is made clear that no further extension shall be granted.
କୋର୍ସ ଗୋଟେ କାଲିଟା ସରେଣ୍ଡର କରିବୁ ତ କାଲି ସରେଣ୍ଡର କରିବୁ
କରନ୍ତୁ ଆଜ୍ଞା ଏତେ ବ୍ୟସ୍ତ କାହିଁ ହଉଛି କରିବେ ନା ଆପଣ କଣ
କାଲିକି ଅଛି ତ
Item 44. Petitioner entered interim bail which will expire on 23/5/2024 to look after the ailing parents. Now the parents are under treatment. I have filed this IA for extension of time for 2 months only.
Same order, 1 month.
1 month.
From 23/5/2024.
Last order रे ଗୋଟେ ଟିକେ typographical error ଅଛି the conditions रे जो granted for 1 month ये जो weekly once appear करिवो for 3 months लिखा जायछि सेटा 1 month last order dated 18/4 small typographical error.
The words for a period of 3 months appearing in condition I of condition I under paragraph
conditions
of order dated such and such be deleted. Yes.
Item 45.
Lordship, can you see the order dated 10/4/2024, para 8 and 9?
8 and 9.
Granted interim bail and directed after release on interim bail within 1 month, he has to give cash security 5 lakhs and property security of rupees 20 lakhs. Thereafter, your Lordship will consider to absolute the bail. Well, on 9/5, on 16/4, he was released on interim bail. On 9/5, he has fulfilled the condition. He has given the cash security of rupees 5 lakhs and property security of 20 lakhs, which has duly been accepted by the presiding officer of PID court.
Yes, sir.
My lordship has only handed over a copy of the order.
You want to file an objection?
No, I will only verify. I will only verify.
You will do one thing. Consider making this order absolute. We'll take it up after vacation. In the meantime, the interim bail will continue.
I have given certified copy of the order.
Let him take instruction. He is applying for the OPID.
Court has accepted.
See, Gopavandhu Das, Learned Counsel.
So, Lordship, can you see the next page on the next? You have accepted the deposit and the property.
Yes, filed the certified copy of order dated 9/5/2024, passed by the court below, showing a deposit of rupees 5 lakhs, property security of rupees 20 upon Sri Vivekananda Bhuya, Learned Counsel for the OPID, who wants to take instructions in this regard. Place this matter in the week commencing. Correct? In the week commencing 24 June, the interim order, the interim bail granted by order dated 10/4/2024 is extended till taparo week jain karo. 1st July 2024. Hello. Urgent certificate copy be granted. On that, this be kept on record. Certificate copy be kept on record.
I may be permitted to submit the xerox copy of that certified copy, or I will take a xerox copy and.
No. The certificate copy should be on record. Certificate copy should.
I will take a certified copy.
The certificate copy of the order be kept on record. On that day, Mr. Bhuya will consider. He has complied with the condition. Why should we keep him in custody? I just want to give him an opportunity to respond. That's all.
The order was passed in presence of the PP before the OPID.
No. Yes.
Item 46.
What is this, Mr. Bhuya?
This is for Lordship may kindly see the in the
ଆପଣ ଜାଣିଛନ୍ ଆଜ୍ଞା ଯାଆନ୍ତୁ ମୁଁ ଏଇଟା ଅନ୍ୟ ମ୍ୟାଟର ନେବି ନା
ସେ ଆଇ ର ନମ୍ବରଟା ଇନଆଡଭର୍ଟେଣ୍ଟଲି
କେତେ ହେଇଯାଇଛି
394 ହେଇଯାଇଛି 294 ହବ
294 ଅଛି ତ
ନୋଟିଂ ରେ ଟିକେ ଆଜ୍ଞା
ନୋଟିଂ ରେ ଭୁଲ ଅଛି କିନ୍ତୁ ଅର୍ଡର ତ 294 ଲେଖା ହେଇଛି
ଆମର 1496 ଆଇ
No, it has been inadvertent as 394 instead of IA 1490.
ସେଇଟା 1496 ହବ
1496 ହବ
ଆଜ୍ଞା
instead of 294.
The IA
number be made. The IA number be corrected as
1496
1496 of 2024. Yes. That's all.
Milord, the interim order is to continue.
Interim order to continue. You list it on the date fixed. Interim order to continue.
Item 47.
May I please, Your Lordship? Your Lordship, I'm seeking modification of the order dated 23/4/2024. Your Lordship, last paragraph. The CLMC is, however, disposed of granting liberty to the petitioner to appraise the IO by furnishing the document obtained by him from the concerned CST under the RTI Act. If such document is produced before the IO within 2 weeks from today, the same shall be considered on its own merit. Your Lordship, I'm only seeking for a stipulated time period in which my document may be considered by the IO, and until then, Your Lordship, no coercive action may be taken against me.
What is this matter?
Your Lordship may remember that I had prayed for quashing of the FIR, where the allegations against me was that I had caused grievous hurt. However, from RTI, I had obtained that the person was never admitted to the hospital on that day. And Your Lordship had granted liberty to me to appraise the same before the IO. However, the same is not being accepted, saying that there is no stipulated time period granted to the IO to consider the same. And Your Lordship.
I don't have the copy of IM.
Serve a copy of the IA. We'll take it up on Monday. In the meantime, you obtain instruction.
Yes.
Well,
Much
why
obliged.
it has not been? Why? How can the IO ignore this order? Direct to the
Only
that
because
if
there is
such
no
document is produced before the IO within 2 weeks, the same shall be considered. How can he not accept it? He may consider it in his own way. He may reject it. He may accept it. That's him. But how can he not accept the document? Anyway, let a copy of the IA be served upon Learned State Council, who shall obtain instructions. List this matter on 21st.
much obliged. Your Lordship.
21st. See, the got the extra these.
Item 48.
Extension of bail. Out of 4, 3 have been granted bail by this honorable court. Only difficulty is the coordinate bench of this honorable court has dismissed my bail application.
Main bail application. So how could I?
In view of Usoduri.
No, I didn't understand.
My lord's bail disposal is fast.
So?
Honorable Chief Justice Pune again
No, I have granted you interim bail.
No, regular bail to all 3.
No, here interim bill for
You are Tushar alias Janmej.
Yes.
But I have granted you interim bail.
Interim bail that I have paid for extension.
So what was rejected? What was rejected? You are saying some bail application was.
Charita accused 3 my lord has granted bail. Mo bail application coordinate bench reject कर देते
अच्छा तापर पुणे आसिला
सेइथे आपण
आसिला पर इंटरिम बेल देली
interim bail देखि सेटा extension
all right considering the submissions the interim bail so granted by order dated such and such is extended by a period of 1 month vacation टा पार करबा
आगे
vacation टा पार हे गेला
नहीं vacation एटा माने बेल देई हबो ना केम कोर्ट बेंच तो रिजेक्ट कर देछि ना तण आपण ही जा करियो आपण करियो
मो हिसाब बेल दो मु देबी कोर्ट बेंच रिजेक्ट कर कोन आले
ना मेन एक्यूज बा देछि
हां हो
सेटा जे डिफिकल्टीज
सेमति किछि कहयो बेल कोन गोटे प्रेसिडेंट कोन देखिए
सेइथे एक्सटेंशन सेइथे इंटरिम बेल
इंटरिम बेल 1 मंथ हो तापर देखिए यस
ठीक है और ना 2 मास कर दोगे
ना मु समस्त 1 मंथ आज करछि 1 मंथ
छुट्टी पड़ जो
मु वैकेशन पर को तो करछि ना
हां
वैकेशन पर केला नहीं 1 मंथ
Item 49.
Duty 1 month 6 weeks कर दे Duty 1 month दिन छोड़ा सब 6 weeks कर दे सब बड़ा 6 weeks कर दवा कहीं कि ना छुट्टी भीतर जो पड़ जाओ पुणे रिलीज ही पर नथि कोन को
Yes, ma'am.
Yes 49
May please, Lordship. Lordship, for modification for corrections of the offences mentioned in the ordering portions para 4.
para 4 what has happened
Sir, basing upon the offences mentioned in the FIR, we have filed the bail application. Your Lordship has granted, and during surrender, during investigations, the offences turned to 417, 294, 493, 503, and 323 of IPC, for which we are unable to comply the order of this honorable court. So that's why.
What are the offences added?
417 and 493.
Good. We'll modify it. Okay. Paragraph 3. Considering the submissions, the offences mentioned under paragraph 3 be substituted as so and so. कर दूँ. These is the IR election to.
Lordship.
IR election.
Lordship.
Alright.
Item 50 along with section on time.
2 weeks for the time.
Item 50. May please, Lordship, modification of order dated 31/1/2024, my lord. Order has been passed. Petitioner deposited 1,50,000. They shall be released on bail. But present.
Last week, my senior take time for file counter, or counter not filing.
None. They are now very prompt in filing counter. They must have.
In some cases. Now the draft counter is ready. We'll file it.
First you say that we will file counter.
Yes.
Then you will say that we are waiting instruction. Then you will say the draft counter is ready. Then you will say the counter is ready. All right. The 2011 matter, Mr. Right, sir. Sri Ardas Leonard AGA submits that the draft counter has been is ready and that the counter affidavit will be filed shortly. Is this matter in the week commencing 24th June? Huh? Oh, sorry. On 28th June, counter will be filed in the meantime. Counter and rejoinder, if any, be filed in the meantime.
Item number 18.
18.
My senior is engaged in another court. I prefer after vacation. After vacation.
After vacation? All right. Leave this matter after vacation as paid for.
So item 24. May please.
This is in respect of the selection of the Hon'Ble worker. But in pursuance to the advertisement, the petitioners applied for the same. Can I have a glance to Annexure 2 at page 14?
This is for final disposal, Mr. Mahanti.
So, taking the advantage of the same, the wrong person has been appointed.
You don't have an interim order.
Say, empty stage appointment he natila. जब नोटिस जाएगी तंग स्पेशल कराला ता भीतर से मैंने
So you should have filed an IA. Further IA.
नहीं फर्दर फाइल करची रिजेंडर फाइल करची सब
IA.
आईए नहीं काउंटर पर रिजेंडर स्पेसिफिक
नहीं IA is there. Your IA is there. No order has been passed.
कोई लिख नहीं जो and even the specific conditions has not been adhered to.
I can hear it, but it will not be possible to pass a judgment. So
can it be Monday?
Monday I can hear it, but what will happen? I will not be able to pass judgment within a week because vacation is over. Vacation for us. In the meantime, we can always say that if any appointment has been made in the meantime, it will be subject to result.
I may pray date be fixed.
Yes. Sri Satyavrat Mahanti, Leonard Counsel for the petitioner, submits that after receiving notice issued by this court, the opposite party authorities have appointed opposite party number 6 as Anganwadi worker in her place, in the place of the petitioner. Stop. This court further finds that the pleadings are complete and the matter is otherwise ready for disposal, but for paucity of time, it is unable to be taken up today. Place this matter on 21st June. In the meantime, if any appointment is made as submitted by Sri Mahanti, the same shall be subject to result of this writ application.
Item 25.
Much over.
Yes, Mr. Satpathy, what is this batch of matters?
My lord, this batch matter, Lordship last occasion directed to file counter, my lord, by the opposite party number 1, my lord. It is a relaxation of age.
He has solicited necessary instructions from the government and would like to relaxation of age, man.
Yes, sir, is a matter relating to selection of Shiksha Sahayak, my lord.
Yes.
The relevant time, my lord. And they were overage, my lord.
Oh, that matter. Yes, yes, I remember. Yes.
Well, with respect to that, my lord, in one of the case, that is WPC number 31468 of 2023, we have already filed a counter filed by the DPC cum DEO.
So will you adopt it for all cases?
It can be adopted, my lord, so far the principle is concerned. But few of the cases, my lord, these are also listed before Honorable Justice V.P. Satpathy, sir.
What can be done then?
And Mr. Sangram Jena, AGA, my lord. A good draft counter he has already received.
No, actually, this matter then it should be heard by one bench.
I can also, but
No, the bench matter hearing over. No, but if you made this submission, I can pass an order directing the matter to be placed before the Chief Justice to assign it to either one judge.
My lord, this matter may be taken up after in the reopening of the after vacation, my lord, so that in the meantime, government is going to file a counter, my lord, and a draft counter has already been received.
All right, what do you say, Mr. Satpathy?
My lord, your lordship, my lord, since
I'll call it on then 21st June.
25th June, but what happened, my lord? In this case, my lord, they have rejected the claim of the petitioner, my lord, saying that is a policy decision of the government.
Yes.
Unless government file counter, my lord, DPC counter is not.
No, he says that he will file a counter.
So far the DPC is concerned, my lord, we have filed a counter. But so far government is concerned, we have received the.
If it comes to policy decision, then it is for you to.
We have received the Parawais comment.
And policy decision, Mr. Satpathy, the court is very slow to interfere. Unless you can show this violation of Article 14 or 21. All those things.
That falls there, man.
So that you prepare yourself accordingly. Sri S.N. Patnaik Learned AGA submits that the decision regarding relaxation of age of the candidates.
Upper age limit.
Upper age limit. This decision not to relax the upper age limit of the candidates is a policy decision of the government for which a counter is to be filed, stating all the relevant facts. Such being the submission, let this matter on 21st June. Stop. Counter affidavit, if any, be filed in the meantime, after serving copy on the other side. Who may file a rejoinder.
On paper, opposite, no one.
Yeah, state yes.
My lord, my prayer, my lord, I have filed one IA, my lord. Then, since there are number of backlog vacancies are there, and the petitioner prayed in the read petitioner, my lord, to fill up the to appoint the petitioner from out of backlog vacancies of 2015 and 16, my lord. And the petitioner obtained the instruction of through RT Act, my lord. A number of posts are there, my lord. In the meantime, government notified for fill up of 20,000 of vacancies, my lord. So that any appointment shall be subject to petition, my lord.
No, सबुआडे काई करिया
ए छुट्टी उतरे सर किछु advertisement
election चलछि किछु हबन
advertisement even
any appointment. I am not saying that
election even June 21 ভিতরে কিছু নেই তো June 21 ভিতরে এই তো June 10 পরে
June 10 পরে
something can happen.
That may be lie over, my lord.
ये lie over. Yes. It have 24, 25,
25, 26, same.
26, 27. Same order.
Well,
Yes.
the counter filed in 31468 to 2023 available.
WPC 31468 of 2022. Item 27. Hela, she's likhi. Counter affidavit filed by opposite party numbers 2 and 4. Yeah. No, Milan State Council submits. And the counter affidavit filed by opposite party numbers 2 and 4 is adopted for the purpose of the counter on behalf of the said parties in the other connected data applications. है ना? सर ले? हैं? वो कौन सेकंड आपने आरएस नवा? देखिए कौन अर्जन कर दो.
Copy notes also, that is
Copies of the advocate counter affidavits we serve.
I may be live.
आइए तो रोले आप किसी और नहीं.
Of live.
Item 4.
Release item of four minors. Alright, here, the appeal arises out of an order passed by the London and District Judge. My lord, the substantial question of law is concerned that this the appellant belongs to a scheduled caste community, Gondabai caste, without taking the prior permission from the competent authority. A seal deed has been executed, which is also complete violation of the
You have 75 days, you have not taken steps for limitation.
limitation petition are filed.
You filed, fine. Actually, limitation petition, dekla.
Otherwise, they can also point out the defect.
They have already pointed out the defect and they have already said steps for limitation not taken.
No, already defect has already been removed. Thereafter, matter also listed for admission. Let it be admitted, you should not.
Yeah, delay thai admit hijo. Second appeal ta. Limitation ta point out question the SRA 75 days. Take steps for limitation in the meantime. I'll call it after vacation. That's all.
Sir.
Sri Panda, Learned Counsel for the appellant submits that he'll take limited steps for limitation. And request for adjournment. Place this matter in the week commencing 24th June. Steps for limitation be taken in the meantime.
So item number 12.
Second appeal without concerning the delay.
I was under the impression that unless there is a defect has been removed, matter could not be listed for admission.
So this is for orders.
Oh, sorry. Yes.
This has come for orders.
May I please your judgment? This is a case. When you confirm judgment, the defendant number 5 is the appellate.
Confirming judgment.
The defendant purchased a piece of land measuring 5 decibel from the recorded owner, defendant number 5. The consultation ROR published in the year 2000. Thereafter, the suit filed by the plaintiff in the year 2012, stating that the consultation ROR is wrong and with a prayer for permanent injunction and a recovery of possession and declaration of right to interest. The plaintiffs in the suit pleaded that during consultation operation, they have filed a suit for permanent injunction against the state, and that suit has been decreed, declaring granting permanent injunction against the state. And they got the occupancy right over the suit land. Therefore, the major settlement ROR, where the note of possession recorded in favor of the plaintiff has been declared as wrong in that suit of the year 1982.
But you said these lands are choco lands?
These land has consolidation choco lands.
So, major settlement ROR kim thela?
1982, the major settlement of ROR is continued. The consolidation operation was started thereafter, and the ROR has been recorded in the name of my vendor for 16 decibel land. Out of I have purchased only 5 decibel land. My land, the consolidation ROR published in the year 2000, the suit filed in the year 2012. Their stand before this suit, since in earlier suit against the state, permanent injunction decree has been passed. This suit is binding on you, and since the permanent injunction decree has been passed, this suit, the possession of the plaintiff has been established.
You are not a party to that suit.
I am not a party to that suit. I have appeared, or other defendants have not filed their written statement. In respect 3 suit land, they have not placed in respect of suit land, as that has been acquired by the government. They are not only claimed in respect of my land, 5 decibel land. And I have raised since the consolidation ROR has been published, any illegality in the preparation of the consolidation ROR is within the domain of the consolidation authority. Civil court has the jurisdiction to
Section 42.
51. Civil court has the jurisdiction only specific circumstances as indicated by our full-based jurisdiction. The court came to conclusion, the trial court came to conclusion that lease granted in the year 1976 in my favor. I have produced the lease order and lease ROR that compared the SAPOG plot number with the consolidation ROR, which is purely within the domain of the consolidation authority. And the trial court concluded that since the lease plot which granted in your favor is not tallying with the consolidation plot, you have this suit land cannot be.
No, but that is a factual aspect that is to be seen by comparing the plot index.
That scope is not within purview of the civil court. Since that is not any irregular procedure adopted by the consolidation authority in preparing the consolidation, that may be a erroneous exercise of jurisdiction. Maybe the error in the jurisdiction, passing the order or preparing the order. The case, the referred the full bench might page 31 of the brief and 19 of the appeal order. The
No, come to the trial court. Trial court order first.
trial court consider.
Let us see the issues.
Issues as per page 6 of the trial court. They though frame 10 issues, 7 issues has been tracked together in all respects. And in
I think issue number 8 would be relevant.
issue number 8 is relevant, but all the issues combinedly considered and finding has been.
So what is the finding? Let us see the gist of the finding.
So far the applicability of the consultation proceeding, page 1149, where the court of conflicting of jurisdiction of civil court and the consultation authority court assessed, bottom of the matter.
Yes.
Page 49, internal page 11. The entries by themselves either do not create title or establish it, and hence it is always open to the civil court to find out the real holder of the title despite any entry settlement of papers. It is also settled that even if jurisdiction of civil court is excluded, civil courts have jurisdiction to examine the cases where the provisions of the act have not been complied with or the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure. If cause of action arose
Oh, that is Mongoli-Jal. Mongoli-Jal, isn't it?
No, the 3 principles is not applicable to the.
So that full bench, I think the statutory tribunal.
But that has been reflected. The 3 principles has been reflected by the trial appellate court judgment in page 31, madam.
Yeah, so what happened? So if cause of action arose after closure of the operation, it is civil court which has to be approved, doesn't that mean? The lawsuit will not be ready. So you mean to say that this was only just a error in comparison of that Sabak and Hal?
That cannot be accepted. There is no field inspection inquiry report is required. That can be taken care of by the consolidation authority.
So it's a correction of ROR basically.
It's purely civil court passed the judgment by correcting the ROR, and 1982 decree has been passed, permanent injunction. As this consolidation operation is going on, we have the state has raised a objection with regard to abatement of that suit of the year 82. In that judgment, I have also.
No, let us see. Let us go to the trial court, appellate court judgment.
Appellate court judgment. Page 31. After giving the
page 31.
Page.
I want to see what are the points whether the civil court declaring suit is justified. This particular point has never been raised.
That the judgment has been quoted by the appellate court, but whether this fact is fitted with the under 3 which principle, that has not been.
Let us see. Where? Page 31.
Page internal page 16, page 29, matter. Page 16, internal page.
Page 16. Let's say page 7.
In the appellate court 3 points.
4 points. 4 points.
4 points. Point 3 consider at a time, and factual aspect dealt with. Thereafter, page 19.
Yes.
Page 19, para 14. Defendant number 5 cannot challenge the title of the plaintiff over the Schedule B land as the state has not challenged the same. So far as the argument led by the non-counsel, the appellant with regard to power of civil courts to interpret the ROR prepared by the consolidation authority. The civil court can interfere in the ROR prepared by the consolidation where the consolidation authority has exercised jurisdiction illegally. That is the principle. Whether such illegality is available here, that has not been. Thereafter, in para.
You mean to say it is just a procedural error?
This is not. This is a wrong by the at best issue with regard to wrong publication of a consolidation error by matching the Sabak and
it's a clerical error.
Or this is the during the inquiry. This is not fitted with the 3 principles outlined in the para 15 minute. The cause of action occurring after the closure of the consolidation operation. The consolidation operation made in the year 2000 prior to the cause of action arose. And if the consolidation authority had taken decision without complying the provisions of the act and not acted in conformity with principle, that is not the question.
All right. Heard Sri P.K. Satpathy, learned counsel for the appellant. Appellant or appellants? Appellant. Appellant. Produce the impugned judgment. Produce the impugned judgments. Stop. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. COD.
COD.
ହେଲା
ଆଜ୍ଞା
ଏଠି COD ଅଛି ଦେଖି ପଢିବେ।
ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ମେ ବି ଷ୍ଟେଟ୍ ଫର୍ଦର ପ୍ରୋସିଡିଂ ଏଭିକ୍ସନ ଅର୍ଡରଟା ହେଇଛି ସେ ସିଭିଲ କୋର୍ଟ କମିଶନର ଡିପୋଜିଟ୍ କରି ପୋଲିସ ଡେପୁଟେସନ ପାଇଁ ଅପଳେଇଲେ।
ହେଲା issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed by Tuesday, by 21st. No, not 21st May. Hello, call for the LCR. List this matter. August.
5th August. We commencing 5th August.
In the week commencing 5th August. IA 1449 of 2023. Further proceedings in execution case number 25 by 2023 pending in the Court of Reliance Civil Judge Senior Division Bhadrak shall remain stayed till the next date.
Item number 13.
Lord, the plaintiffs are the appellants before my lord against the reversing judgment.
The Order 41 Rule 11?
Miller.
Plaintiffs are the appellant. It is the reversing judgment.
In a reversing judgment.
Yes.
Lordship say the suit was one for permanent injunction and correction of record of right along with declaration of fishery right, occupancy right, as it is a fishery source. The case of the plaintiff that they got the lease, their ancestor got the lease in a unregistered deed prior to 1943, and they have excavated it for the purpose of agriculture as well as fishery.
Yes.
So their right after the vesting, their right was recognized, and in the tenant ledger, it was reflected in their name. They have paid rent. Due to non-payment of rent for a considerable period, a certificate proceeding was initiated against them for the self-same land, and the rent was realized through certificate proceeding along with the interest. Thereafter, in the Hall settlement, it was erroneously recorded in favor of the government in Abada Jogya Anavadi Khata. Therefore, the plaintiff filed the suit seeking declaration with other consequential relief. During the trial, the plaintiff have examined the witnesses, and after considering the evidence, the London Trial Court recorded conclusion. Your Lordship may kindly come to page 30, my lord.
33.
30.
30, yes. Yes.
My lord, that is 8th line from top. The rent receipt marked Exhibit 22A, Exhibit 4 series, the tenant's ledger marked Exhibit 3, etc. The defendants, on the other hand, have not filed a single scrap of paper in support of their case, and as such, the defendants have failed to prove their case against the plaintiff. Thus, taking into consideration the provision of law discussed here above and the documentary evidence on behalf of the plaintiffs only can be held to be the occupancy rights of the suit land, and the MSRR in respect of the suit land, showing the suit land as Abada Jogya Anavadi, is held to be wrong, illegal, and inoperative. Now coming to the next issue, issue number 4, the London Council for the plaintiffs further contents. So and so, the Lordship may turn to page 31. The last 8 lines from bottom. Thus, leasing out the suit land in favor of department number 3 by the Tahsildar Chandbali on 28/6/88 in absence of the report of the revenue supervisor is not genuine, and there is no legal validity to record the suit land in the Soirac register. The Learned Counsel for the plaintiff further cites so and so decision. Then the conclusion, your Lordship may kindly see page 34, Miller.
These are 33.
Hence considered, first line, Miller, hence considered the plaintiff being the occupancy rights over the suit land and having acquired the suit land for more than 30 years, the defendant number 1 and 2
can be permanently restrained from putting the suit land into auction, while all the defendants can also be permanently restrained from creating any sorts of disturbances in the peaceful possession of the plaintiffs, and hence considered all these issues stand answered in favor of the plaintiff. So the plaintiff suit was decreed, and challenging that, two appeals were preferred. Your Lordship may kindly see, some of the villagers, they, with obtaining the leave, filed an appeal challenging the judgment and decree. They said it is a communal land, so because of the decree, we have been suffered. And the other appeal was filed by the state government. Both the appeal were considered together. The Lordship may come to page.
And the decree was reversed.
Decree was reversed on the finding that since it is recorded as Pani Nala, it cannot be leased out.
Why? Why?
Where the learned DJ got that finding, he has not recorded it. But he said since it was recorded as Pani Nala, page 71, last 4 lines. This court fails to understand how can a private person claim title over natural source, which is meant for communal benefit, or like a Pani Nala, as stated in Exhibit 5, which is of Kisam Nala, and in detail description of the Kisam of the land and its boundary, it is mentioned as Pani Nala. In the aforesaid circumstances, this court finds that the finding of the learned trial court that MSRR with respect to the suit land is illegal and inoperative with regard to the title of plaintiff and is not binding on them is perverse and without legal reason.
All right.
So that he on that score, Millard, he has lost sight of the fact that a communal land has only been defined in Act 1 of 1948. I have got a copy, extract of that copy for your Lordship's consideration. Yes. If it is recorded in Gochara Sarvasadharana or specifically set apart in either of the ROR as communal, then only it is a communal. Otherwise,
Gochara Rakhita Sarvasadharana.
It କୌଣସି settlement ରେ ଗୋଚର ରଖିତ କି ସର୍ବସାଧାରଣ, but because your Lordship visualize.
So we say substantial question will frame that whether that finding is contrary to the
right.
That will do.
Miller.
That will cover everything.
Miller.
Isn't it? And Mr. Vishal, you are appearing through caveat.
I have pro caveat for the villagers.
Villagers or what?
We are using that land as a
hearing kariba, finally hearing kariba, admit ho. That's the Vivekananda Bhuya learned counsel.
One line I can show from the trial court judgment that where the trial court has held that there are others, Paninalas are there,
So
for
that's
which
not-
it cannot be said that it is used by the
but
villagers for their own purpose.
No, but the finding of the first appellate court in reversing the judgment, he has
No, my lord, other aspects has already been dealt with.
certainly. But
Not
this
on that aspect only, other aspects have been dealt with.
no, but that seems to have weighed upon his mind that this being a private land,
Yes,
this being a private this is a Pani Nola,
I am not disputing that.
Pani Nola, how could it be recorded?
Well, that is not relating to the recording only. That is in the name of the government, and that is
We
used
admit
by
it,
all
yeah.
the villagers for their.
Mr. Vishnu will admit it, will finally hear it. Finally hear it, expedite kori hearing karo. That's the Vivekananda Bhuya learned counsel for the appellants for that. Appellants. Peruse the interim judgments. Considering the submissions made and the grounds raised, comma, the second appeal is admitted on the following substantial question of law.
সেই গ্রাউন্ডটা নেই না
ନେଇଛି ନା
नहीं फास्ट ग्राउंड 1 टा नहीं चेंज तमते खाली रिफ्रेश करे नहीं अच्छी ना
Notification.
अच्छे जे अपन रेफरेंस से नोटिफिकेशन और लिखना यस लुक एट ग्राउंड नंबर 1 सब्सटेंशियल क्वेश्चन ऑफ लॉ नंबर 1
improperly
ହେଲା না কোর্ট কনফার্ম করবে
I am framing it whatever I have understood I will frame it
Again.
whether the finding of the first appellate court relating to the communal relating to the nature of the suit land being communal land is correct in view of the definition of communal land as per the Odisha Communal Forest and Private Lands, Prohibition of Alienation Act 1948. Satik.
My lord, along with that,
Sri, since the respondents, you are appearing for all the respondents?
No.
Then?
Four to
My lord, he is appearing for private opposite party.
3 to 7, my lord.
3 to 7. So, and you are appearing for?
no, no,
Government appearing.
ଆଉ ଦିଟା second appeal file କରିଛି along with this second appeal ସେଟା ଆସୁ
Sir, next time ଆସ।
ନାଇଁ ଏକାଠି ଆସିଯିବ ଚାରିଟା
ନା ଏଇଟା ମୁଁ ଆଗ ତାକୁ ଇଏ କରିଦଉଛି ତାକୁ ସୋମବାର ଦିନ ଆଣିବା ଆରୋରା
already admitted ଏଇଟା ତା ସାଙ୍ଗରେ ଆସିବ ଆଉ କଣ
ନାଇଁ ଏଇଟା
support କରୁଛି Mr. Bhuyan
no I'm saying that but technically it has to be admitted again, that appeal also has to be admitted over the technical notice ଯିବ এটা second appeal ଟା ନା ଏଟା civil matter ଟା ଏଟା
3 to 7 I am.
read ହେଇଥିଲେ ହେଇଯାଇଥାନ୍ତା 3 to 7 only।
ଆଉ ତ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଛନ୍ତି ନା।
ନା ନା ଆଉ ଗୁଡା ଅଛନ୍ତି।
ଆଚ୍ଛା ହଉ, ଗଭର୍ଣ୍ଣମେଣ୍ଟ can appear for 1 and 2?
Yes. Better notice if goes.
ଆଚ୍ଛା will issue notice।
Copy ଦେଇ ଦିଅନ୍ତୁ।
State government?
Mr. Bhuyan. No, Mr. Bhuyan, let notice go. Let notice go. Why should he issue notice to opposite party numbers 1, 2, 8 and 8 to 19 by registered post with AD, returnable within 4 weeks. Requisites be filed by Tuesday. By Tuesday, the date since respondent numbers 3 to 7 have already appeared through caveat, let copy 4 and copies of the appeal memo
14th they have served.
Have already been served upon their counsel Sri A.K. Vishwa. No notice, no further notice needs to be issued to them. Call for the LCR. List this matter.
12th August. We
commencing 12th August. And you give the list of your matters. It will come on Monday. The same order will be passed. All right.
ମୁଁ ଗୋଟେ ମେମୋଟା କରି ଦେଇଦେଉଛି
interim order ଦେଇଛି status quo
କପି ଦେଇନାହାନ୍ତି ମତେ
ଦେଇଛି
ନା କପି ଦେଇନାହାନ୍ତି
ତା ସେଇଟା ପଛରେ ଦେଖ
କପି ଦିଅନ୍ତୁ କପି ଦେଇନାହାନ୍ତି ମତେ କପି ଦେଇନାହାନ୍ତି ନାହିଁ ଆଜ୍ଞା ଦେଇନା
ଆରଟା ଦେଖିଲ
ନା status କୋଟା ଦିଆହବ ତ
ନା ନା କାଇଁ ମାନେ ମୋର କପିଟା ପାଇନି ମୁଁ କହିବି
ଅପିଲଟା admit ହବ
ମୁଁ କେବେଟା ଫାଇଲ କଲି ଯାଇ କହିବି ଆପଣ ସବୁ କହିବେ ତ ମୁଁ
ପଛରେ ଦେଖ ଅଛି ନା
ହେଲା
କଣଟା ଦେଖୁନାହାନ୍ତି ମତେ ମୁଁ ମିଛ କହେନି
ଦେଖ ଏଇଟା କଣ ଏଇଟା କଣ ଏଇଟା କଣ
ହେଲା
ଏଇଠି
ରିସିଭ କଣ କରୁଛି ଆରେ କପି ନାହିଁ ଆଏ ନୁହେଁ
କଣ ଏଇଟା
ଆଏ ମୁଁ ନ ଦେଖିକି ଦସ୍ତଖତ କରିଥିଲି କାହିଁକି ଆମ ବିଶ୍ୱାସ କରି ମୁଁ ମନା କରୁଛି ନା
ଆଏ ଦେଇଛି
along with ଆଏ ଲେଖି ଦେଇଛି
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏଟା ଥାର୍ଡ ପାର୍ଟି ରାଇଟ କ୍ରିଏଟ ନ କରୁ ସେତିକି
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଥାର୍ଡ ପାର୍ଟି ରାଇଟ କ୍ରିଏଟ ଆଇ am not we will use it but no third party
ୟୁଜ ମନା ଗୋଟେ ତ ପାର୍ଟି ରାଇଟ କ୍ରିଏଟ କରିଯିବ ନା
IA 1218 of 2023. In the meantime, no third party right shall be created in respect of the suit land over the suit land till the next date.
Only my prayer is you should not be deprived of using this and
I pass that order. I have said only no third party right.
No, because
only third party right
only that much. We will use it for our own purpose of cultivation because we are not using it for any pisciculture for our other purpose. We villagers are not using it.
I have not restricted. Nobody is restricting. We have only said that third party right shall not be created.
ଲିଜ ଦେଇପାରିବେ ନା
ଆମେ ବି ବିକ୍ରି କରିପାରିବୁ
And that matter will come on Monday.
ଆପଣ 2 ମିନିଟ ଟାଇମ ନେବେ 2 ମିନିଟ ସରିଯାଉ ମୁଁ କହିବି
Item not 15. Only one line can.
Please, my lord.
My objection will be recorded relating to.
Heard Sri Vivekananda Bhuyan for the appellant petitioners, and Sri A.K. Vishwa, then counsel for the respondent numbers 3 to 7. Sri Bhuyan prays for passing an order of injunction in respect of the suit property, to which Sri Vishwa objects by submitting that his clients have been utilizing the suit property for cultivation purposes. Yes, sir. So, considering the submissions.
ନା କଲ୍ଟିଭେସନ ଫିସିକଲଚର ପାଇଁ ସେମାନେ ପ୍ରେୟାର କରିଥିଲେ
ନାଇଁ ମୁଁ ଆଜ୍ଞା ଟିକେ ଆପଣ ରୁହନ୍ତୁ, ଆପଣ ମଝିରେ ଇଣ୍ଟରପ୍ଟ କରନ୍ତୁନି ପ୍ଲିଜ। ଆଇ ଏମ୍ ଡିକ୍ଟେଟିଂ ଦ ଅର୍ଡର ଇଫ୍ ୟୁ ଇଣ୍ଟରପ୍ଟ।
ନାଇଁ ସାର୍
submissions. And the fact that the appeal has been admitted, this court directs that no third party rights shall be created over the suit land till the next date. That's all. I have already recorded your submission that you are using it for cultivation purposes. That's all.
Item 15.
Item 15.
May I please, my lord? I am in BC, my lord.
Sir, yesterday I told you, sir, please come physically.
Yes. I am sorry, my lord. I am unable to.
Sir, I am calling it on Monday.
Monday.
Sir,
Okay.
is this matter on Monday?
Obliged, my lord. Obliged.
2007 ରେ ଦିଟା କୋର୍ଟ ଥିଲା 9 ନମ୍ବର 10 ନମ୍ବର 9 ନମ୍ବରରେ ଜଷ୍ଟିସ ପଣ୍ଡା ବସୁଥିଲେ 10 ନମ୍ବରରେ ଜଷ୍ଟିସ ମହାନ୍ତି ବସୁଥିଲେ ତ 9 ନମ୍ବରରେ ଆଣ୍ଟିସିପେଟରୀ ବେଲ୍ ଦିଆହେଲା ତ ମୋର ଆଣ୍ଟିସିପେଟରୀ ବେଲ୍ ଗୁଡାକ ଉଠିବାକୁ ଭାରି ଅସୁବିଧା ହେଲା ମୁଁ 482 ଫାଇଲ କଲି ବେଲ୍ ହେଲା ତାପରେ ଯୋଉଟା 9 ନମ୍ବର କୋର୍ଟ ଯୋଉଟା ରିଜେକ୍ଟ ହେଲା ଆଣ୍ଟିସିପେଟରୀ ସେମାନେ 482 ଫାଇଲ କଲେ ସେ ତ ଖାଲି 482 ଖାଲି ଆଣ୍ଟିସିପେଟରୀ ବେଲ୍
But that is wrong. It may have been that. That is wrong. That is wrong.
Indiscriminate.
I have been very clear from the very beginning. I have granted, in many cases, I have granted no course of action. But bail, I think Mr. Mishra is there, he will certify. I have never granted.
ସେତେବେଳେ CRLMC ରେ ଯାହା ବେଲ୍ ହେଲା ସେପଟୁ ରିଜେକ୍ଟ ହେଲା ଏପଟେ ବେଲ୍ ହେଲା
Golden period.
So that is, you see, I am not blaming the lawyers for that. Whatever happens.
ଆମେ ଯୋଉଠି ପାଇବୁ ସୁବିଧା ଆମେ ଚାଲିବୁ
So list is over. So on Monday, say go to matter or you go to matter. Second appeal. Supplementary next week. I will not take up a weekly list of what is it 2 दिन पे. 2 दिन पे हमारे चाहे supplementary जितने